court minute, I gave the decision that restoration can be allowed, and thereafter the matter was.
ତାଙ୍କର ପ୍ରାଇଭେଟ ସେକ୍ରେଟାରୀଙ୍କ ସାଙ୍ଗରେ କଥା ହେଇକିନି ସାର୍ଙ୍କୁ ପଚାରିକିନି କୋଉ ଦିନ ଗୋଟେ ଇ କରି କରିଦେବେ ଶୁକ୍ରବାର ଦେଖିନ
And that brief is before list is since
shall I give that memo
published.
ଗୋଟେ ଆଗ ଡିଆର କୁ ପଚାରିବେ କି ସାର୍ ମୋ ସାଙ୍ଗରେ ବସିକି ନେଇପାରିବେ କି ନହେଲେ ସେଟା ଦେଖିବା
जस्टिस मुरलीधरन सर से करते चीफ जस्टिस मुरलीधरन सर थे सेतला करते हां सेप्टेम्बर मास लिस्ट आसी फाइल थुआई छी
मैटर कहीं मो पाखरे आसिला आज नहीं किसी बेंच এটা তো আমার অ্যাসাইনমেন্ট না ये বুঝে না না আমি খালি এটা যে অর্ডার করতে এটা ফেসিলিটি আমি এই ব্যাচকে প্রথম করতে হইব এটা সেই ম্যাটারটা দরকার ଆଜି କଣ ସେ କୋର୍ଟ ହଉନି ଆଜି ବି ସେମିତି ଆସେନି ଯେ ତାଙ୍କ ନାଟ ଆସେନି କିଛି ନୋଟିସ୍ ନାହିଁ କାଲି ଗୋଟେ ଥୁଆ ହେଇଥିଲା ଆସିକି ଅଛି ଦେଖି
Supplementary list item number 1.
Right. On mentioning yesterday, this matter has come at the father of the appellant died, my lord.
Your bail application was rejected on 5/12/2023, right? So this application is for that interim bail on the ground of
Initially, I have filed the IA 38/24 on the illness ground of the father of the appellant. The case was listed yesterday. Yesterday, the father of the appellant died. For that reason, I have.
So where is your affidavit?
My lord, I have already filed in.
And you have sought a copy of this affidavit.
Yes, I do.
What instruction you have?
Yesterday died, madam.
Oh, have you got the report?
Written I have not received it. Over telephone morning I got the information that he died. I have told him to send
which IIC?
That is
Jajpur.
Jajpur, my lord. Sadar.
Why don't you obtain it in writing?
Yeah, I have told him to send a written.
Just send it. We are passing the order.
I'll.
IA number 38 of 2024. This is an application for interim bail. The application was filed on the ground that the father of the petitioner was suffering from paralysis due to sudden brain stroke, and after undergoing treatment at SCB Medical College and Hospital, Qatar, being referred by CSC Dharmasala, he was bedridden and unable to move and to do his regular work. The medical documents were annexed to the interim application. Yesterday, mention was made by the London Council for the appellant, and one affidavit was filed wherein it is indicated that
the father of the appellant died on 30th June 2024. A copy of the affidavit was furnished to the learned counsel for the state, who was asked to obtain instruction. Today, the learned counsel for the state has produced written instruction received from IAC Jajpur Sadar Police Station that the governments taken in the affidavit are correct, and that the father of the appellant died on 30th of January 2024. Considering the submission made by the learned counsel for the respective parties, the governments taken in the affidavit, the submission made by the learned counsel for the petitioner, that the presence of the petitioner is very much necessary to perform the obsequious ceremony. We are inclined to release the petitioner on bail, interim bail. The interim bail period shall start from 1st February 2024, and the petitioner shall surrender before the London Trial Court, that is Additional Session Judge Jajpur, in City Sessions number 174 of 2017. So if we calculate, then it will be by 13th everything will be over, and so surrender on 19th February 2024. The matter will be listed on week commencing from 26th of February 2024. The Land Council for the appellant shall produce the surrender certificate being disposed of. Then IA number 1763 of 2023 says an application for stay of realization of fine. It is allowed. Okay. Free copy, that copy, urgent certified copy be granted during course of the day. Hello?
Beg pardon. Earlier a date was fixed to be listed. It is noting there in the date was fixed for after rejection of the bail. A date was fixed.
No, it's all right. Since we another order is superseded, so you have to file your surrender certificate. Then then the matter will be then listed to 18th. So first you comply the order. This is subsequent order. So Mr. Das, you filed that instruction. Yes.
Quickly list item number 5.
My lord, I have already submitted their chat along with the chat. ଦେଖନ୍ତୁ କାଲି ଦେଇଛି କାଲି ଦେଇଥିଲି
Yes.
My lord, first, your lordship, page 40, last page. That is the custody certificate which I filed by my lord and brother in counter affidavit, page 40. So is in custody about 19 years. After deducting the parole period, it is common.
Which annexure?
Annexure,
Yeah.
my lord, page 40, last page.
Data.
Page 40, more noting the data ଦେଇଛି ମୋଟା ଦେଖ
Okay.
ଆରେ ଆପଣଙ୍କ ଜିନିଷଟା ଦେଇଛି
18 years, 11 months, 21 days.
Yes, my
Yeah.
19 years.
19 years.
Total 18 years.
18 years.
Yeah.
So ground of rejection is that due to young age, he has not lost his potential for committing further crime. I have filed rejoinder affidavit.
Wait. Yes.
My lord.
No, the
Will-
earlier one, as you mentioned,
My lord.
on 10/3/2021,
My lord.
it was rejected on the ground of adverse report.
Adverse,
Then you challenge that rejection order before this court or what?
I have not challenged, but I have prayed for consideration of my appraise.
No,
That
you
is-
mentioned on 8/2/2023.
8 to 22. That
So
is
the Honorable Court directed the petitioner to approach so and so in CRLMP number so and so. What is the CRLMP?
My lord, annexure
What
four,
is the prayer in this
page
CRLMP?
17. Annexure 4, page 17. Page 19, internal page. Paragraph 3, it is mentioned.
Hmm.
In this CRLMP, the petitioner seeks a direction from this honorable court.
What you are placing?
Page 19 of my
19
of my petition.
petition,
My petition.
not this compilation.
No. Annexure 4, page 19. Paragraph
19 is the Justice Panigrai's order.
My lord.
Yes.
So here is a direction to consider. Para 3. Para 3 is the prayer.
Okay, then what happened?
Then, my lord, my matter was placed before the board and board has rejected the same by the order dated 2/6/2023, annexure 5.
Yes.
Page 26.
Hmm.
Reason is due to young age, he has not lost his potential for committing further crime. In my rejoinder affidavit, I have stated that for consideration of potentiality, your lordship, last page of my counter, my rejoinder affidavit. By reason of one's age, one cannot say whether the convict has still potential.
Page 20.
Page, my lord, this is the
Hey.
matter.
Rejoinder affidavit कहीं?
Rejoinder affidavit
Last.
annexure D/4.
No. My lord, this is the decision of honorable
40?
Apex Court. Para 8. Only that reply.
Hey, put was. है नहीं कहीं.
Count rejoinder नहीं. ठीक है कॉर्म हाँ ये surrender है page 14 में देखिए running page
Table file is this. Why it has not been done? How then, what is the purpose of in paperless court?
Affidavit.
What is the page number?
Page number 3.
yes running page 51 56 decision document
Yes.
Reported in AR 2000 Supreme Court, page Lakshmana Laskar versus the state of West Bengal. It has been held that by reason of one's age, one cannot say whether the convict has still potentiality of committing crime or not, but it depends on his attitude to the matter, which is not being taken by the government. Your Lordship, my petition annexure 6, page 27. This is the report where it has been stated. Your Lordship, kindly prove. Enquiry report of parlor release of live convict, page 27, annexure 6.
Yes.
With reference to the letter subject cited above, it is to intimate that the matter has been inquired by the IIC Town PS. After inquiring, IIC Town PS opined the following points. The law and order problem may not be arise now on the release of convict on parlor, as the party is not residing in the locality. At present scenario, there is very less chance of a personal grudge of convict. The convict, if released, may lead normal social life. His wife is living alone and suffering from chronic disease. So, per my respectful submission would be, my lord, there is paramount consideration of Lakshmana. I have provided that judgment.
Yes.
Whether the offense, these are the paramount consideration, your lordship. Got it. Page 6, paragraph 6, sorry, my lord. Paragraph 6. Oh, of course, my lord, that is not one miss. Whether the offense affected the society at large, the probability whether there is any fruitful purpose for confirming of this convict anymore, whether there is any chance of a future reoccurrence of committing crime, whether the convict has lost his potentiality in the crime committing, socio-economic condition of the convict's family. That should be taken into consideration. So in the present case, my lord, the report has submitted under Annexure 6, and in view of the judgment that age is not the only criteria to consider the potentiality. So my application,
Where have you, which paragraph you placed?
my lord, that judgment,
Huh?
paragraph 6.
No, that number 4 is whether the convict has lost his potential in committing the crime.
Crime.
Yes.
That is the one of the
That has been
criteria.
discussed in para 8.
Para 8.
So
That
why
is
don't
the-
you place it?
My lord, para 8.
Yes.
Yes, my lord.
How it has been dealt with.
Dealt with, my lord. Secondly, your lordship kindly para 8. If we look at the reason given by the government, we are afraid that the same are probably irrelevant or devoid of substance. Firstly, the view of the witnesses who had been examined in this case or the persons in the locality cannot determine whether the petitioner would have a danger if premature release, because the persons in the locality and the witness may still live in the past and their memories are being relied upon without reference to the present, and the report of the jail authority to the effect that the petitioner has reformed himself to a large extent. Secondly, by reason of one's age, one cannot say whether the convict has still potentiality of committing the crime or not, but it depends on his attitude to the matter, which is not being taken into consider by the government. So, attitude, I have submitted already
Annexure 6.
6.
No, annexure attitude is not annexure 6.
Annexure
This
6, my
It may lead normal social life.
No, how you are behaving with
My lord,
the jail.
I have
that is-
specifically stated that there is
Ah.
no adverse remark in the jail while I am
Yes,
in
Mr.
custody.
Das,
My lord,
what is his conduct?
that is not,
You have calculated, or you have the authority has taken into account that he is young, so there is possibility of committing the
yes,
crime.
my lord, the previous report I will go to kindly my counter, my lord.
Hmm.
I have a glance on the Annexure B by 4, page 6 of my counter.
Counter affidavit के? Paperless row. Why it is not there in the heading that it's a counter affidavit, so that once we click it will go to the counter affidavit? Where have you mentioned in this index? What purpose this index is? Page 6.
My lord, Annexure B by 4, my lord.
B by 4, it is not page 6, page 7. All right, yes, sir.
Page 7, sorry.
Yes.
Right, no, page 7. My lord, with reference to the letter subject cited above, it is intimated that the phrase inquiry report of IAC so and so that one, as the convict is in jail custody in this sole case and had been acquitted in series of cases, he may try to take revenge upon his against party for whom he is being convicted, leading to and order, law and order problem in the locality. Thus, there is very possibility of law and order problem in a convict is released.
No, Mr.
My
Das,
lord.
this is a report
Of
dated
2020, my lord.
18/9/2020.
My lord.
He is
My-
relying on a report
Huh.
of 2023.
Now, because in this report, present report, my lord, my lord, in present report, my lord, that is a report where it has mentioned that in para 2, para 1, my lord, the law and order problem may not be arise now on the release of the convict on parole, as the opposite party is not residing in the locality. For the timing periods, just parole not for the premature release, total full release, my lord. The report says that if you release on parole, for the timing there, because the opposite party are not in locality, there may not be any law and order situation.
No, you are right that that word parole has been used.
My lord.
But when they have filed such a document,
My lord.
so in your counter affidavit,
My lord.
what have you stated that that the how it is his because it law requires that is about the attitude is to be taken into account, not the age is the sole criteria.
My lord.
So attitude means once the person is remaining in jail custody for 18, 19 years.
My lord.
So the best person to say is the jail
Jailer.
superintendent. So what is the report of the jail
That I
superintendent?
have
How he is behaving
My lord.
with the others in the jail, and any kind of incident has happened which indicates that no, he has not repented or is continuing in the same. So what is that report?
That I have not submitted.
Number two, if you are telling that there may not be any difficulty for parole, and there may be difficulty if he is released, remission is granted, and he reside there permanently, right? So there must be something on record. You have not taken any averment. Have you taken any averment that that was an application?
No, that I have not.
So
Because
Annexure 6 is only meant for parole. It is not. So if you are not, then you have no answer to that. We can say that that is still then, since he is involved in number of cases,
number
we are
cases,
giving you an
in
opportunity.
the young age, he has
It's all right. You obtain a report from the jail superintendent. Number one, he's telling that everything is okay. It is your contention that.
My lord, I have specifically stated at paragraph 2, page 6 of my grounds.
Yes.
I have. For that, the jail authorities have satisfied that the petitioner has already been changed himself and is leading in a normal life in the jail. The conduct
Paragraph
of the
6.
Paragraph 6, ground 6, page 6, paragraph, sorry, my lord, page 6, paragraph 4, 4 and 5. I have specifically stated.
IV you would have.
IV and V.
IV out kuda
B.
B.
The conduct of the petition from
All
the
right.
jail.
So IV of V upar apanakar instruction.
yes,
hala?
Yes.
And then since he is relying on that annexure 6.
No.
Okay, but the word has been used as parole. So on that also you take instruction from that very gentleman superintendent of police Puri. Okay, if he is prematurely released, then whether there would be any problem, because according to you that the opposite party might not be staying in that locality for a temporary period, but once they return back and this man will stay there for all time to come, then there may be some problem. So on that aspect, you take instruction. And the other thing which we want to the other day, that
the previous at the time of the conviction,
what was the
I have submitted.
What is that?
That is same all. Same was there.
At the point when the conviction was made,
Conviction was made on 21/3/2020, 2012, my lord.
12
At that time, the 2010 guideline was in force.
ସେତେବେଳେ କଣ ଥିଲା?
Same condition was there.
କୋଉଟା କୁହନାହାନ୍ତି?
Code, my lord, 2010.
ଏଇଟା ଅଛି. Whether the convict has lost his potential for committing this
Right.
one. Okay. So I would have opportunity for the Land and Council for the state produced the resolution dated 5/5/2010, the Law Department, Government of Orissa, relating to the guidelines for the State Sentence Review Board to review the sentence awarded to a prisoner and for recommending his premature release in appropriate cases. The Land and Council for the state further submitted that the petitioner was found guilty by the Land and Trial Court, that is First Additional Session Judge Puri, in ST case number 4/78 of 2003 on 21/3/2012 under section 302, 324 of the Indian Penal Code and section 25 and 27 of the Arms Act. And he was awarded sentence of life imprisonment. And at the time of conviction, the resolution dated 5/5/2010, the aforesaid resolution dated 5/5/2010 was in force, which inter alia indicates under the heading of eligibility for premature release that the State Sentence Review Board shall take into account, inter alia take into account, whether the convict has lost his potential for committing offense, considering his overall conduct in jail during the 14 years incarceration. Subpara. The Land and Council for the petitioner drew the attention of this court to ground number IV and V of the writ petition, wherein it is mentioned that the jail authorities have satisfied, are satisfied that the petitioner had already changed himself and is leading a normal life in the jail. And the conduct of the petitioner from the jail record is found to be good. For which the jail authorities are favorable to him and recommended his name for release on parole. When a query is made to the Learned Counsel for the state as to whether he has received any report from the concerned jail superintendent where the petitioner is lost about the conduct of the petitioner, his attitude, the Learned Counsel for the state seeks some time to obtain instruction in that respect. The Learned Counsel for the petitioner filed a date chart along with the judgment of the Learned Trial Court, the judgment of this court in the criminal appeal, so also the order passed by the Honorable Supreme Court in the SLP, so also the custody certificate of the petitioner dated 2/1/2024, which indicates that the petitioner has already undergone substantive sentence of 18 years, 11 months and 21 days. Land counsel for the petitioner drew the attention of this court to the ratio laid down in the case of Lakshman Naskar versus State of West Bengal, reported in AR 2000 Supreme Court 2762, wherein while dealing with the point whether convict has lost his potentiality in committing the crime, it was observed in paragraph number 8 that by reason of one's age, one cannot say whether the convict has still potentiality of committing the crime or not, but it depends on his attitude to matters. The ground of rejection of the premature release of the petitioner as per Annexure 5, which is impugned in this writ petition, is that serial number?
Serial number, my lord. 63, page 26, Annex 5.
That due to young age, the petitioner has not lost his potential for committing further crime. The Learned Counsel for the petitioner submitted that in view of the ratio laid down in the aforesaid case, that is life convict Swanso versus Swanso 2000 Supreme Court 2762, the ground of rejection is not justified. And he has also brought to the notice of this court to the report of the Superintendent of Police Puri dated 7/2/2023, which is addressed to the Collector and District Magistrate Puri regarding that is the inquiry report, report nagari inquiry report on parole release of the petitioner, wherein it is mentioned as follows. Quote कर देवे page 27 annexure पूरे जो चारिटा point से देजन सेटा quote करते. The Learned Counsel for the state, however, submitted that in serial number 1, it is mentioned that if the petitioner is released on parole, then there would not be law and order problem. But it has not dealt with the aspect of the premature release of the petitioner. And he may be given some time to obtain a further report from the Superintendent of Police Puri bracket like diyantu opposite party number 6 about the to furnish an inquiry report about the premature release, the effect of premature release of the petitioner. Put up this matter. କେବେ ଆଣିବାକୁ ଆମର ଦିଟା ଜିନିଷ ଆପଣ ଅବଟେନ୍ କରିବେ କୋଉ କେବେ ଗୋଟେ ସପ୍ତାହ ତ ଦରକାର
19 ତାରିଖ
19 all right and give a copy to the Learned Council in advance so that he may list this matter in the week commencing from 19th February 2024. The Learned Council for the state shall in advance supply the report of the jail superintendent, so also the inquiry report of the superintendent of police, Puri, to the Learned Council for the petitioner in advance. No? Okay.
3 copy
3 copies.
today.
My lord, one thing more, my lord. That report with the socio-economic condition as per their resolution. That may be also called.
No, let him. It's a because it's a in the meantime, you see, 10 months have already passed. So let a further report be called for. You are right about that word that they have used. Now the thing is that if that ground is not sustainable, then it is again to be directed for reconsideration. That would be the. But let us see that report, and if it is comes in your favor, it's well and good. How many cases were there against this man?
Exactly, I have blocked it.
And what is the status of those cases?
Acquitted.
Line
All the cases acquitted.
Have you taken averment?
I have stated in the that
In the
Then
counter,
it's,
it has
then it's all right. Then it's all right. Not necessary. Yes, Mr. Das.
Item 11, madam.
Dear.
Please, Lords. In this case, my lord, the appellant has been the appellant has been convicted for offense under section 302 and sentencing him to RI life.
Nando, is it the appointment by the legal aid committee or we appointed you? As the
Your lordship appointed.
Okay. So it's a 302 case. No?
Yes, my lord.
How many persons face trial?
For 20. Total 20 persons have been faced trial, my lord. Official witnesses have been
20 persons face trial.
No, only
Yes.
one, your lordship.
Sorry, my lord. One sorry, witness. Sorry, भूल कह दिली.
You're
Witness.
asking a question, how many persons?
Sorry, my
face
lord.
trial?
Sorry. One person.
So
Only
he
sole
that,
accused.
Sole accused, face trial, convicted. Okay.
Yes, yes,
All right. Please come to the first information report.
my lord. Page 13, relevant part at page 15, my lord. Dillinath Mahato is the
PW?
informant.
PW?
2. PW 2.
Yes.
ମୁଁ ଦିଲନାଥ ମହାତ ପିତା ଥାନା ବିଶ୍ରା ଜିଲ୍ଲା ସୁନ୍ଦରଗଡ଼ ଆଜି 17/7/2004 ରିଖ ଏହି ରିପୋର୍ଟ ଦେଉଅଛି କି ଯେ ରାତ୍ରି ପ୍ରାୟ 8:30 ସମୟରେ ମୋ ଘରେ ମୁଁ ଏବଂ ମୋ ଜ୍ୱାଇଁ ମକର ମାହାତ ଭାତ ଖାଉଥିଲୁ।
Just a minute. ମୁଁ ଏବଂ ମୋର ଜ୍ୱାଇଁ ମକର ମାହାତ is
11 PW 11 my lord.
PW 12.
12
ଆଚ୍ଛା।
PW 12
ହଁ ମୁଁ ଏବଂ ମୋର ଜ୍ୱାଇଁ
ହଁ
ମକର
ହଁ
ଭାତ ଖାଉଥିଲୁ। ହଁ
ଭାତ ଖାଉଥିଲୁ ହଠାତ୍ ଚାର ଓରାମ
ଚାରୋରମ କିଏ? Appellant?
accused yes
Okay.
ଓରାମ ମୋ ଘର ଭିତରକୁ ଦୌଡ଼ି ଆସି କହିଲା
Just a minute. Yes, ହଁ।
ମୋ ଘର ଭିତରକୁ ଦୌଡ଼ି ଆସି କହିଲା ବଞ୍ଚାଅ ବଞ୍ଚାଅ ମତେ ମାରିଦେବେ। ମୋ ଘର ବାହାରେ ଥିବା ଏକ ରମ୍ଫାକୁ ଧରିଥିଲା। ମୁଁ ତାକୁ କହିଲି ତୁ ଆମ ଘରକୁ କାହିଁକି ଆସିଛୁ? ସେ କହିଲା ମତେ ମାରିବାକୁ ଦୌଡାଉଛନ୍ତି। ମୋ ରାଗ ଶାନ୍ତ ହେଇନି। ମୁଁ ଯାହାକୁ ହେଲେ ଜଣକୁ ହାଣିବି। ମୋର ଜ୍ୱାଇଁ ଏବଂ ମୁଁ କହିଲି ତୁ ଆମ ଘରୁ ପଳେଇ ଯା। ଚାର ଧରିଥିବା ରମ୍ଫାକୁ ମୋ ଜ୍ୱାଇଁ ଛଡେଇ ନେଲେ ଏବଂ ସଙ୍ଗେ ସଙ୍ଗେ ଚାର ଓରାମ ଘରେ ଥିବା ଏକ ଟାଙ୍ଗିଆ ଧରି କହିଲା ଯାହାକୁ ହେଲେ ହାଣିବି। ଭୟରେ ମୁଁ ଏବଂ ମୋର ଭାଇ ନନ୍ଦକୁ ଧରି ଉଦ ଘରକୁ ଥାନାକୁ ଫୋନ କରିବାକୁ ଗଲୁ। ଫୋନ ନ ଲାଗି
go slowly. ତାଠୁ ଛଡେଇ ନେଲା। ଦେନ୍ ଇଏ କଣ କଲା? ଗୋଟେ ଟାଙ୍ଗିଆ ଧରି କହିଲା ଯାହାକୁ ହେଲେ
ଟାଙ୍ଗିଆଟେ ପାଇଲା ତା ଘରେ।
ଦେନ୍
ସିଏ କଣ କଲା ନା ଇନଫରମାଣ୍ଟ ତା ଭାଇ ନନ୍ଦକୁ ଧରିକି ପାଖ ଘରକୁ
ଏବଂ ମୋର ଭାଇ ନନ୍ଦ କିଏ?
ନନ୍ଦ ତାର ଏଇ ଯୋଉ ଇନଫରମାଣ୍ଟ ର ଭାଇ।
ଆରେ PW କଥା କହୁଛି।
ନନ୍ଦ ହେଲା
PW 9 ମାନ।
PW 9 ନନ୍ଦକୁ ଧରି ଉଦ ଘରକୁ ଥାନାକୁ ଫୋନ କରିବାକୁ ଗଲୁ। ଫୋନ ନ ଲାଗିବାରୁ ଘରକୁ ଫେରି ଆସିଲୁ। ଘରକୁ ଆସି ଦେଖିଲୁ ଯେ ନାତୁଣୀ ମମତାକୁ ଚାର ଓରାମ ଏକ ଟାଙ୍ଗିଆରେ ତାର ହାତକୁ ହାଣି ଜୀବନରେ ମାରିଦେଇଛି। ମୋର ସ୍ତ୍ରୀ ଦଶମୀ ମାହାତ, ଝିଅ ସୁଭଦ୍ରା ମାହାତ ଏବଂ ଜ୍ୱାଇଁ ମକର ମାହାତ ଦେଖିଛନ୍ତି।
କିଏ କିଏ ଦେଖିଛନ୍ତି? ମୋର ସ୍ତ୍ରୀ ଦଶମୀ ମାହାତ କିଏ? PW 5. Okay, then ଝିଅ ସୁଭଦ୍ରା
PW 4
okay
ଏବଂ ଜ୍ୱାଇଁ ମକର ମାହାତ PW 12 ଦେଖିଛନ୍ତି। ମୋର ଜ୍ୱାଇଁ ମକର ମାହାତ ପାଟି କରିବାରୁ ତାକୁ ହାଣିବାକୁ ଟାଙ୍ଗିଆ ଉଠେଇଲା ଓ ଜ୍ୱାଇଁକୁ ହାଣିଦେବ ବୋଲି ଉଦ୍ୟମ କରୁଥିବା ବେଳେ ସେ ତାଙ୍କ ଜୀବନକୁ ବଞ୍ଚାଇବାକୁ ଯାଇ ଚାରୁଓରାମ ଠାରୁ ଟାଙ୍ଗିଆ ଛଡାଇ ଆଣି ତାର 2 ଗୋଡକୁ ହାଣିଦେଲେ। ସେ ରକ୍ତାକ୍ତ ହୋଇ ମୋରି ଘରେ ଅଛି। The incident took place on
ଏ ଯୋଉ
7
ନାତୁଣୀ ମମତା ମାନେ ସିଏ ହଉଛି
ଛୋଟ
ମକର
ଝିଅଟା
ମାହାତର ଝିଅ।
ମକର ନାଇଁ
ଆଉ?
ଆଉ ଗୋଟେ ଝିଅର ଝିଅ ଇଏ ମକର ମାହାତ ଆଉ ଗୋଟେ ଝିଅର ଜ୍ୱାଇଁ।
ଓକେ
ସେ ଝିଅଟା ଏଠି ରହୁନି ତାର ସେଇ ଖାଲି ନାତୁଣୀଟା 8 ବର୍ଷର ସେ ସେଇଠି ରହିକି ପଢୁଥିଲା ଅଜା ଘରେ।
Okay.
ସେ ଶୋଇଥିଲା
So now how many eyewitnesses are there?
20 total 20
ଓ
witness
କଣ ଆପଣ କହୁଛନ୍ତି ମୁଁ?
Eye witnesses.
eyewitnesses my lord
3.
5 eyewitnesses, Lord.
five
Please tell you.
PW4,
Yes, PW4,
5,
PW5,
8,
PW6.
my lord,
Yes.
8,
Uh,
and PW12.
PW2 এই जो हाँ
PW2 is a post-occurrence witness.
So 5 eyewitnesses, that is one part of the evidence. Any other material leading to discovery,
no
any other material, extrajudicial confession, or the case rests upon the eyewitnesses account of these 5 eyewitnesses and coupled with that PM report which the doctor conducted.
And the axe that was seized from the spot, the blood group of human origin has been found on that.
First tell us that who is the doctor who conducted PM?
PW1. Your
PW1.
Lordship.
PW1. And axe was seized at the spot.
Lordship.
And it was found to be bloodstained.
My
Yes.
Lordship.
And doctor examined that axe.
Yes.
It was sent by the IO to the doctor for his opinion whether the injuries are possible or not. Yes,
Yes,
Ms.
Your
Nanda?
Lordship.
Okay, so
Right.
that report is there. Report on axe, possibility of injury. So before going to the eyewitnesses, let us start with that PM report which has been proved by PW1.
My lord, page 23. Page 23, the opinion of evidence of the doctor.
Wait, Peter, how many injuries were noticed? External injuries.
First, the page 23 contains the injury of the accused, my lord. Second page रे
ଏଇଟା ହେଲା
accused
appellant ର
हाँ
ତାର ଅଛି ଗୋଟେ incised wound ଅଛି on the lower lip lower lip
leave
limb,
sir
right,
leave
of the lower leg. Okay, the second one is also showing lateral part of the lower third of the right leg. अच्छा ଗୋଟେ ଦିଟା injury ରହୁଛି leg portion ରେ, but injuries have been opined to be simple in nature. Okay. Both
fracture
legs
ହେଇଛି
appear to be fracture ହେଇଛି pura.
ଆଜ୍ଞା
Yes, Your Lordship. And another
Detail-
doctor has examined that aspect, Your Lordship.
So it is now grievous injury.
Lordship.
Fracture injury means grievous injury. Okay, now then the same doctor conducted PM.
ଆଜ୍ଞା
Yes. So PM indicates that Mamata, one injury, first injury is on the neck. Second injury is on the left mandible. Third injury is on the
upper arm
right upper arm. Okay, ଡାହାଣ ହାତ. Fourth injury is right forearm.
forearm
Right.
the right side.
All the above injuries might have been caused by sharp cutting weapon. Antemortem in nature. Okay, cause of death was due to profuse hemorrhage and shock.
So
And he has proved the report exhibit 2. Then he examined that axe which was produced by the IU, and his opinion is that injuries detected on Mamata Mohanto would be possible by the axe produced. Mamata is the deceased. Okay. Now you come to the evidence of the eyewitnesses. The first one you said PW4, right, Mr.
Yes.
Mishra?
Lordship.
এসিটা ଟିକେ বন্ধ করো, মধ্যে বন্ধ করো, তারপর ফোন চলে একাত্তর পুরা। Yes, please press that.
Page 30, my lord.
Yes.
I know the accused Mamata Mahato. I know the accused Mamata Mahato is the daughter of my sister. Mamata Mahato was remaining in our
By the
house
way, what is the age of that deceased?
8 years, my lord.
Oh.
Se ଶୋଇଥିଲା ଖଟ ଉପରେ ଇଏ ତାକୁ ଯାଇକି
Mhm.
ଆଣିଛି.
Hmm.
Was remaining in our house and continuing her study. On 17/7/2004 night, Mamata was sleeping on the cot and I was sitting on that cot. My father and brother-in-law Makara Mahato were taking their meals. In the meanwhile,
Other
accused
means PW?
Makara 11, Makara Mahato 12.
No, this is 12. My father, সেটা মকর PW 12 বেলা তার brother-in-law.
Huh.
So what about the father? Is PW?
The 2
PW2. Okay.
informant.
Yes. PW2 didn't support the prosecution case.
No, he has supported.
He's supporting, but he in his cross-examination, my lord, he has stated about the mental condition of the accused.
No,
He
no, no.
stated
You said that PW2 is not an eyewitness. You said that.
He's not an eyewitness.
Okay. Because what this witness says that he was also present and taking meal when the occurrence took place.
again.
Okay. Please continue.
Makara Mahato were taking their meals. In the meanwhile, accused came inside saying "Boncha, boncha," and my father went out to see if anybody was chasing the accused to assault. None could be found, and my father went to inform police for entry of accused inside my house with a stick in hand. In the meanwhile, the accused picked up axe from our house and dealt blows to the neck and right hand of Mamta Mahato, who was sleeping on the cot. As a result of injury inflicted, Mamta died. When accused was escaping after assault, my brother-in-law tried to catch him. Accused also attempted to assault him, but my brother-in-law caught hold of him and retained in the house. The incident was reported to police. Police came and took the incident was police came and took the accused. Police also saw the dead body of Mamta Mahato. I was examined by police and I made statement before the police.
No, it's all right. But in the chief examination, as it appears, he has not stated how the appellant sustained injury.
My lord,
Appellant sustained 2 injuries, no? And that has been opined to be grievous in nature. And both the injuries are on the leg.
that appellant has sustained injury by virtue of PW12 chasing him and assaulting him, your lordship. That part he has stated. Accused
No,
also attempted.
this witness
My lords.
has stated up to, you see, the accused was detained.
Lordship.
Then police came and so he was throughout present, right from the beginning when the occurrence started till the police came and arrested. this man was present
Lordship.
at the spot, but his evidence is silent as to how the appellant sustained those two injuries.
My
Okay,
lords.
that is what.
In her cross-examination, my lord,
Wait, just a minute.
Also, it appears, Your Lordship, this witness is 15 years old. And no question has been put to her also.
No, the law says that, let us say that those formalities have not been done.
Lordship.
Rational answers, whether he is able to give, that is not there. But if he's examined and cross-examined and he has faced the questions of both the side, prosecutors, also the defense counsel, and answered it, then the court can, from the answer given, can say that whether he was having maturity, or whether he was realizing that uh, able to give rational answers or not.
My lords.
So merely because those formalities have not been done, and he's a 14 years and boy,
girl.
girl, sorry, girl. So that cannot be a ground. But once any type of why she assaulted that child, because
In her cross-examination, Lordship, may see,
hmm?
the accused was telling himself that to give him marriage elsewhere, he would obey everything when he came to our house. When he came,
how the accused is ଏମାନଙ୍କ ସାଙ୍ଗରେ ତ ତାଙ୍କର କିଛି
ତାହାର କିଛି ସମ୍ପର୍କ ନାହିଁ. He is a mad man, my lord. In the informant stated about that he is a mad since 10 years.
Just a minute. He was stating that to give him marriage and always give nonsense. So you mean to say absolutely no motive on the part of the appellant to assault the deceased, who was 8 years old, and she was sleeping on at that
Yes,
point.
yes.
Okay, complete the cross-examination.
Again, when he came inside our house, he was sweating. He was also trembling. When accused said that he was killed some of them, I went out of the room. ସେମାନେ ସବୁ ଦୌଡ଼ି ପଳେଇଲେ. I myself, my brother and my brother-in-law went out of the room out of fear. When accused dealt blows to Mamta, we were in the veranda of the room. There was no electric light in my house. At that time, DB light was burning and it was in the veranda. I had seen accused assaulted Mamta on the veranda. ମାନେ ସେ ଦୂରରୁ ଥାଇକି ଦେଖିଛନ୍ତି. No one is present there because of the attitude of the accused, my lord. ସମସ୍ତେ ଦୌଡ଼ି ପଳେଇ ଆସିଥିଲେ. Subsequently, the ମକର ମାହାତ snatched away the axe and given 2 blows to 2 legs of the accused. And the accused was sitting there all the night. Even the IO came there and not shifted the accused or the dead body in the night. On the other day, they were shifted. And the accused was sitting in that position in there.
Okay, just now you are focusing on that 84 of the Indian Penal Code, on soundness of mind.
Yes, my lord.
So
Court has not given any effort to bring
it's
out
alright.
that.
So this is one aspect, because absence of motive is one factor. Then telling everybody that give him marriage or else he would obey, and he would obey everything when he came to Acha. So then Okay. What PW2 says, you said that something about that
My lord,
madness.
in his at page
No,
20,
when you are press the entire evidence. So let
My
us see
lord.
that.
page 26.
Because according to PW4, this man was also present
This man was
and
present.
taking food at that point of time. Yes.
My lord, ଗୋଟେ ଜିନିଷ ଖାଲି when the accused entering inside the house of the informant, immediately informant going away to call to telephone the police. He was not there. He came after the occurrence.
Okay, just place it. Let us see that.
Dilnatha Mahato
PW is the informant, right?
informant. Dilnatha Mahato. I know the accused. Mamata Mahato, who was daughter of my daughter Lakshmi Mahato and was remaining in my house and was prosecuting her study. She was 8 years old. In the last Sravana at 8:30 p.m., while I was taking my meal, suddenly accused came shouting, "Bancha, bancha." He was holding a stick, wooden stick. I asked the accused CORAM to go out of my house, but he remained standing by the said side of the door leaf inside the house. I called my brother Nandakishore Mahato and informed him about accused remained standing inside the house.
Nandakishore is PW?
9.
Yes, PW.
And informed him about accused remained standing inside the house and was not going out. So myself and my brother went to inform police. I could not contact the police over phone for some disorder in the phone line. On return to my house, I found cut injury on the neck and right hand of my granddaughter.
That means, while he was absent, this occurrence has taken place. That is what he has stated.
Again,
That he came and
found
this appellant came and stood near the door leaf and he was shouting, "Bachao, bachao," right?
again.
Then
ତାଙ୍କରି ଘରୁ ସେ ଆକ୍ସ ଆଉ ରମ୍ପା ଧରିକି
went outside and tried to contact the police. It was not possible. Okay, then he returned, found that the occurrence has already taken place and the deceased is dead. All right, then continue. I lost
right
from
hand
my
neck and right hand of my granddaughter Mamata while she was sleeping. I learned from my son-in-law Makara Mahato that when he attempted to catch the accused also attempted to cause injury to him and he moved his body, so injury could not be caused to him. And my son-in-law snatched the axe from the accused, assaulted him by the handle and caught hold of him. I informed that the incident to ward member Purna Mahato, who was went to Bisra PS. He informed the police about the incident. After this information was given to police, the police station, the police officer came, inquired about the incident from me, and I narrated the incident as deposed to the court today. The police officer took the accused who was detained in my house. My granddaughter died instantly at the place where she was assaulted. The police officer came and saw the dead body of my granddaughter when I was present. In cross-examination, my lord, 10 years before Makara Mahato developed mental derangement, I made statement to police in my house.
Okay, now this is one eyewitness. Then the next eyewitness, you said it is PW5.
Lordship.
Come to the evidence of PW5. Let us see.
PW5 is Dasami Mahato, my lord. I know the accused about 7 to 8 months back. At night, accused inflicted injury by axe to that time Mamata was sleeping inside my house. Accused assaulted on the neck and hand of Mamata and she died. In cross-examination, it is not a fact that I had not seen accused assaulted by axe to my granddaughter.
Who is this man?
Dasami Mahato is the wife of informant Dilnath Mahato.
Okay, wife of PW2. Yes, next eyewitness is PW6.
Damayanti Mahato. See, Sagar Mahato is the neighbor, my lord. Sagar Mahato is a witness PW7, and this Damayanti Mahato is his wife. I know the accused. About 7 months back, accused came inside the house of Dilnath Mahato with stick in hand and picked up Rampha and said he would kill whosoever would come. He assaulted by axe to Mamata, who was sleeping on the cot. He dealt 2 blows to the neck and 2 blows to the right hand of Mamata and died. Mamata died. Cross-examination. I was present in the house where accused dealt blows to Mamata. Police did not inquire from me. Lordship, se Subhadraର statement ରେ se କହିନି.
नहीं अच्छा फिर अभी ये करी sanitize को. Yes, please.
The eyewitness PW4, my lord, the Subhadra Mahato, where she stated some name, she has not stated about Damayanti Mahato, my lord. She was not an eyewitness, she was not there, but court has taken her as she is the eyewitness, my lord. But she is not the eyewitness.
He said that this PW6, how is related to the family of the
neighbor, my lord, neighbor. As per the spot map, Sagar Mahatara ଘରଟା ୟାଙ୍କର ଘର ପାଖରେ.
Neighbor of PW1, right?
ଆଜ୍ଞା, PW2.
Sorry, PW. And in the cross-examination,
in her cross-examination,
was present in the house where the accused
I was present, Bhuji se.
What
But
is not stated in
no.
the chief examination, you are very seated in the cross-examination.
Again.
That is how the defense counsel is putting question. He has not stated that I was present and I saw the occurrence. You brought it out in the cross-examination that he was present in the house. Okay, the next one is PW.
8, your lordship.
Similarly, this PW5 has also not stated that I was there, but still,
See,
a question was asked. It is not that I have not seen.
PW's 5 presence is natural, my
No,
submission.
she has not stated in her examination chief that she was present. But in the cross-examination,
not
being
referred
suggested, she said, no, it is
no,
not
it's
the fact
not
that I have not seen.
Lordship.
Fine.
Okay, then the next witness is PW8.
PW2. 8, my lord. PW8 ହେଲା wife of ନନ୍ଦକିଶୋର ମହାନ୍ତ, ଭାଗ ମହାନ୍ତ. ଏଇ ଯୋଉ ଭାଗ ମହାନ୍ତ ଯୋଉ ନନ୍ଦକିଶୋର ମହାନ୍ତ ଗଲା ଇନଫରମାଣ୍ଟ ସାଙ୍ଗରେ ଫୋନ କରିବା ପାଇଁ. ୟାର ସ୍ତ୍ରୀ ହଉଛି ଭାଗ. ସେ କିନ୍ତୁ FIR ରେ କହିନାହାନ୍ତି ଯେ ଭାଗ ଥିଲା ବୋଲି ଘରେ. I know the accused. Accused assaulted Mamta by axe while she was sleeping in the house of Dilnatha Mahanta. I had seen accused dealt blows by axe. I made statement to police. It is in
That's
cross.
the suggestion. It's notified that I had. ये से family ର member ନୁହନ୍ତି।
ସେ family ର member but FIR ରେ ତ କହିନି ସେ ଭାଗ ଥିଲା ବୋଲି ଘରେ। ନନ୍ଦ କିଶୋର ତାର ଭାଇ।
ସବୁ ଜିନିଷ କୁହାହବ ନା କିଏ ଥିଲା କିଏ ନଥିଲା।
No.
FIR is not the encyclopedia. Just
Lordship
to set
में
the law into motion, it is
in
laws
the
and
the
prosecution witness.
जो main
Stated that Bhago was there.
Bhago was there, but in the statement of Subhadra, she has not stated about Bhago.
You first finish the only left out eyewitness, that is PW12. Then you make your submission. PW12 is the last eyewitness as you. That is at page 42.
Makara Mahantaman.
Yes.
I know the accused. I knew Mamata Mahanto 7 months back at night. Accused dealt blows by axe on the neck and hand of Mamata Mahanto while she was sleeping in the house of Dilnath Mahanto. Mamata was 8 years old. As a result of assault, she died. I assaulted on the legs of Chara Oram. I detained him. Police came and took the accused. In cross-examination, there was no enmity of Chara with Mamata. Accused had no relationship with the family of Mamata. Accused would murder others. I beaten him and detained him. I had no enmity with the accused.
Any other witness has given any indication about that
My lord.
section 84 IPC?
My lord, page 40, the witness.
40?
Page 40. Witness PW 11, my lord. The wife of the accused, Najia Oram.
Yeah.
The accused is my husband. I do not know who had murdered Mamata Mahanta Mahanta to court. It is not a fact that I stated police that on 16/7/2004 at night, Charu Oram, my husband, went out of the house with wooden thenga in hand, and on the next day I learned he had dealt blows to Mamata, granddaughter of Dilnatha Mahanta of a village Khotanga Kudara, and murdered her. And that Charaoram also attempted to assault Makara Mahata by axe, and that Makara snatched the axe from him and dealt blows to his legs, and his legs were broken. In cross-examination, they କହିଛି 3 days.
I do not know mental condition of the accused when he was in my house. So he was the best witness to say it. The wife of the accused, he doesn't say that any kind of unsoundness of mind.
See, coach, 3 days before accused was sent to jail, he was living with me and he was moving like a madman.
Not living with.
He was not living with me and he was moving like madman.
But what about the last line? I do not know what was the mental condition of the accused when he was mine. Okay, any kind of medical documents have been filed?
No document, but the doctor, PW 10 my lord. See କହିଛନ୍ତି, he is the doctor who examined his X-ray report. The accused X-ray report examine करथिले. He suggestion तांकु दिया ହେଇଛି. He stated in her cross examination that uh, the mental condition of the patient could be ascertained by clinical examination. See, the accused was not clinically examined, my lord.
What is such abnormality behavior apart from the fact that the prosecution has not brought on record any kind of motive to kill a girl child aged about 8 years while she was sleeping in her house? Se asikini choto chuataku thik achi repeated blows ଦେଇଛି ମାରିଛି. But if you say that that is one of the factor for this unsoundness of mind, then बाकी जो ओराल एविडेंस रहुची ता स्त्री रो एई टाइप रो एविडेंस रहला जे मु कहि परिबिनी आ बाकी गोटे लाइन कहिछि जे से बुलुथिला आउ पीडब्ल्यू 2 रो स्टेटमेंट आसुची जे 10 वर्ष तळे ये मेंटल डिरेंजमेंट रो डेवलप हेतला. But again we are to find out two aspects. One is that legal insanity that is relevant under section 84 and his condition at the time of occurrence. Somebody suppose he was having some kind of mental problem 10 years back, but during by passage of time, see, he becomes okay. And at the time of occurrence, there is no such symptoms. So merely because at one point of time your mental condition was not good, that cannot be a ground to give you the benefit of section 84 of the Indian Penal Code.
As per the statement of the witness PW 4, my lord, as he came to the house of the informant with a trembling and in a fear condition that some people are chasing him to kill. Therefore,
in fact, at least nobody was chasing.
Nobody, but that feeling is that somebody is chasing him. For that, he is coming to kill a person. To whoever will come, I will kill him. This is the behavior. No intention is there. Even Lordship may see the deposition of 20, the deposition of PW 20, the IO. His conduct is that he is ratire gala. ଦେଖିଲା ଏମାନଙ୍କୁ ଏଇ ଅବସ୍ଥାରେ but not shifted, even not totally avoid the situation and
after the occurrence the appellant was present.
Yes,
very much there.
ରାତିରେ ତା ଘରେ ଥିଲା.
Where is the evidence?
PW 20, my lord, page 50.
Page 50.
On 17/7/2004, I was working as SI of police at Mishra PS. On the day, one Dilnath Mahanta of village Kotanga Kudara submitted written report which revealed commission of cognizable offense. So the then IAC registered PS case number 61 of 2004 and directed me to take up investigation. Exhibit 11 is the report. Exhibit 11/1 is the endorsement of signature of Goranga Mahanti IAC of Bisra PS. Accordingly, I took up investigation. I examined the complainant and the scribe of the report, Ramdev Mahanta. I proceeded to the spot. I visited the spot. Since it was night, I could not prepare spot visit report. So on the next day morning, I visited the spot. I issued requisition for medical examination of accused Chara Oram Charo Oram was referred to Raulkela Government Hospital by the medical officer of Mishra CSC Constable 316 S.K.SAHOO and Havildar D. Soren were deputed to escort the accused to the medical. I again proceeded to village Khatanga Kudar. I examined the witnesses. I held inquest over the dead body of Mamata Mahanta in presence of witnesses and prepared inquest report exhibit 4 already marked as exhibit 4 by 4 in my exhibit 4 by 4 is my signature. I seized the sample and the blood stained earth from the house of Dilnath Mahanta in presence of witnesses under seizure list exhibit 5 and exhibit 5 by 3 in my signature. I seized the axe from the place of incident is in presence of witnesses and prepared seizure list. Exhibit 6 and 6 by 3 is my signature. I sent the dead body with a requisition to CSC Bisra from for postmortem on 18/7/2004. I seized the blue color chodi and common certificate on production by escorting constable Sasikanta Khaka under seizure list exhibit 10 by 3 is my signature. Received telephone message from medical officer about discharge of Charo Oram. এটা ভুলে 16 ହେଇଛି এটা 26/7/2004 I proceeded to Raulkela Government Hospital. I issued requisition to the medical officer of RGH of collection of sample blood and nail clipping and accused Charo Oram. I examined. I arrested the accused on 26/7/2004.
Where he found the accused, where he has stated. You said that the accused was present in that spot itself, or in
It cross-examination during investigation. I could know Makara Mahanta assaulted the accused after murdering Mahanta, the niece of Makara Mahanta, when accused was attempting to assault Makara Mahanta. Makara Mahanta assaulted the accused. It is not a fact that
It is against you. What that was an insult.
insane. My lord, say informant statement ଆଉ ସେ ୟାର statement ହଉଛି PW4 ର ଯେ ସେ ସେଇଠି ଥିଲା ବୋଲି
PW4
4 ସୁଭଦ୍ରା କହିଛି ସେ ସେଇଠି ପଡିକି ଥିଲା
PW4
PW4 my
କୋଉଠି ଆପଣ ଦେଖିଲେ?
reported the police.
Police came and took the accused.
A cross examination when accused dealt blows to Mamta, we were in the
Page 31. Accused also attempted to assault him by so and so. Instead of report to police, police came and took the accused. Police was also saw so and so. So till the police came, he was there.
He was there. Police same day नहीं थे, next day नहीं.
Assaulting my brother-in-law put forth so and so. The incident was report to police. Police came and took the accused. Police also saw the dead body of so and so. I was informed.
No, he was detained. He was not
Yes.
that on his own.
ଗୋଡ଼ ତ ଭାଙ୍ଗି ଯାଇଥିଲା ଯିବ କେମିତି?
On his own volition, he was there. Two things are, he had already sustained injury, grievous injury.
ଦି ଗୋଡ଼କୁ ହାଣି ଦେଇଥିଲା ସେ ଯିବ କେମିତି?
ବାକି ଜିନିଷ ହଉଛି ଡିଟେନ୍ କରିଦେଲା। ଆପଣ ଯଦି କୌଣସି ଘଟଣା ଇଏ କଲା ପରେ ଯଦି ସେମିତି ରହିଥାନ୍ତା ତାହେଲେ ଯାଇ ନଥାନ୍ତା, ତାହେଲେ ଗୋଟେ ଆଡିସନାଲ ଫ୍ୟାକ୍ଟର ଆସିଥାନ୍ତା ଯେ ଅର୍ଡିନାରିଲି ଯଦି ନର୍ମାଲ
ଯିବ କେମିତି ସେଠୁ?
ନାଇଁ, apart from that detain ବି ରହୁଛି, detain କରାହଉଛି। ତେଣୁ because 105 of the Evidence Act says that the burden lies on you to prove this mental unsoundness of mind. It's in one of the exception.
Melod ଆଉ ଗୋଟେ decision ଟା ଏବେ ହେଇଛି ଯେ ଯୋଉଟା
ମିଛ ନା ମୁଁ ଜାଣିନି ତା ଗୋଡ଼କୁ ଜଣେ ହାଣିଲେ ଜାଣିନି ଦେଖ 40 ରେ It transfers from evidence so that he assaulted on your leg and detained you. What you have to do, learning. Transfer when you attempt something. Tax and assaulted you. What you have to do, learning.
What that decision says?
My lord, the burden of proof lies on the accused to prove to the satisfaction of the court that one is insane while doing the act prohibited by law. Such a burden gets discharged based on prima facie case and reasonable materials produced on his behalf. The extent of a probability is one of preponderance. This is for the reason that a person of unsound mind is not expected to be proved his insanity beyond a reasonable doubt. Secondly, it is the collective responsibility of the person concerned, the court and the prosecution, to decipher the proof what insanity by not treating it as a adversarial.
এটা কেবেকার রেফারেন্স
My lord, এটা এটা 12/1/2023 ରେ decide ହେଇଛି ପ୍ରକାଶ ନାୟାଲ versus State of Goa, reported in my lord 2023 5 ACC 673.
এসিসি রেফারেন্সটা কাଇଁ হ্যাঁ 2023 5 এসিসি 67. Which paragraph deals with it?
This is paragraph 8 and my case is also similar 21 paragraph, my lord, similar fact.
Wait. Paragraph 8.
My lord.
Burden of proof does lie on the accused to prove the satisfaction of the court that one is innocent while doing the act prohibited. Such a burden gets discharged on prima facie case and reasonable material produced on his behalf. The extent of probability is one of the terms. There is this the reason that for so-and-so is not expected to so-and-so again. Second, it is the court and the prosecution to decide for the proof causing insanity by not treating as a person presumed to be innocent once there are adequate materials available. Presumption get discharged. ଆଉ ଗୋଟେ କୋଉଟା କହୁଛନ୍ତି? Which
paragraph 21 is the fact of the case, my lord. It's similar to my case, poorly similar to my case.
Here, evidence is there, but your lordship, medical evidence is there in this case.
Hmm?
Medical evidence of schizophrenia and other anxiety, neurosis, disease, other things are there. That is not there in the present case, my lord.
In this case, my lord,
You have not produced anything.
No evidence has
That is the problem there. Because what this para 8 say that the burden of proof does lie on the accused to prove to the satisfaction of the court that one is insane while doing the act prohibited. Such a burden gets discharged based on prima facie case and reasonable materials produced on his behalf. The extent of probability is one of preponderance of probability. ତେଣୁ ଆପଣଙ୍କ ତରଫରୁ କ'ଣ ମ୍ୟାଟେରିଆଲ ପ୍ରମାଣ ହେଇଛି? ଆପଣଙ୍କ ତରଫରୁ କିଛି ନାହିଁ, ମେଡିକାଲ ଡକୁମେଣ୍ଟ ନାହିଁ, ନାଇଁ ଆପଣଙ୍କର ପ୍ଲି ଅଛି, ବାକି ରହିଲା ଆପଣ ଗୋଟେ ଦିଟା ଜିନିଷ ପ୍ରସିକ୍ୟୁସନ ଏଭିଡେନ୍ସକୁ ରିଲାଏ କରିକିନି କହୁଛନ୍ତି. ଫର ଏକ୍ସାମ୍ପଲ PW2 ର ଭର୍ସନ ଦ୍ୟାଟ 10 ବର୍ଷ ତଳେ ଆପଣଙ୍କର ମେଣ୍ଟାଲ କଣ୍ଡିସନ ଠିକ ନଥିଲା. ନମ୍ବର 2 ଆପଣ କହୁଛନ୍ତି ଛୋଟ ଛୁଆଟାକୁ ମାରିବାର କୌଣସି ମୋଟିଭ ନଥିଲା. ନମ୍ବର 3 ଆପଣ କହୁଛନ୍ତି ଯୋଉଟା ଯେ ସେ ଜାଗାରୁ ପଳେଇଲାନି, which my esteemed brother has already pointed out that for both legs where there were incised wound and it was fracture wound, and not only that he was detained, so there was no occasion for him, there was no scope on his part to leave that. He could not have in such a situation ଯେତେବେଳେ ତାକୁ ଡିଟେନ୍ କରିଦିଆଗଲା, ତା ଗୋଡଟାକୁ ହାଣି ଦିଆଯାଇଛି, ସେ ଯିବ କ'ଣ ଫ୍ରାକ୍ଚର ଇଞ୍ଜୁରି ହେଇଯାଇଛି. ତେଣୁ that would not be much helpful. ଆଉ ବାକି କ'ଣ ରହିଲା?
FIR story that he rushed to the house of
House of the
the
informant.
informant and said some people are chasing
Chasing
Phil.
him.
So
There was no one was there.
they
The feels
went.
he feeling that someone chasing, but no one is chasing. He say gote attempt नहीं चीज़
बाप जो ही देखिले के नाहाती
नहीं.
तब करिए सब he was trembling.
Again.
And you come that in that very decision, some other observation has been made,
My lord.
which has been given. You come to paragraph number 12. First 11 you place. The court on its part has to satisfy itself whether the act was done by a person with an unsound mind with the rigor of section 84. Then the decision that is relied upon Dayabhai Shaganbhai Thakkar.
My lord.
And you read that portion.
The doctrine of burden of proof in the context of the plea of insanity may be stated in the following propositions. The prosecution must prove beyond reasonable doubt that the accused had committed the offense with the requisite mens rea, and the burden of proving that always rests on the prosecution from the beginning to the end of the trial. There is a rebuttal presumption that the accused was not insane when he committed the crime. In the sense laid down by Section 84 of the Indian Penal Code, the accused may rebut it by placing before the court all the relevant evidence, oral, documentary, or circumstantial, but the burden of proof upon him is no higher than that rests upon a party to civil proceedings. Even if the accused was not able to establish conclusively that he was insane at the time of committed the offense, the evidence placed before the court by the accused or by the prosecution may raise a reasonable doubt in the mind of the court as regards on one or more of the ingredients of the offense, including mens rea of the accused, and in that case the court would be entitled to acquit the accused on the ground that the general burden of proof resting on the prosecution was not discharged.
So what it says that suppose, let us say he has failed to establish conclusively that he was an insane person, but the prosecution case is doubtful.
My lord.
Then also the benefit of doubt can be extended.
Attributed, my lord.
But here that situation doesn't arise. The situation is that number of eyewitnesses have stated that it is you who assaulted the deceased, a child aged about 8 years, in their presence, and nothing has been elicited in the cross-examination. So come to paragraph number 13.
The court in the case of Bapu Supra has held that the onus proving unsoundness of mind is on the accused, but where during the investigation previous history of insanity is revealed, it is the duty of an honest investigator to subject the accused to a medical examination and place that evidence before the court. And if this is not done, it creates a serious infirmity in the prosecution case, and the benefit of doubt has to be given to the accused. The onus, however, has to be discharged by producing evidence as to the conduct of the accused shortly prior to the offense and his conduct at the time of or immediately afterwards, also by evidence of his mental condition and other relevant factors.
Please, next. Mere
abnormality of mind or partial delusion, irresistible impulse or compulsive behavior of a psychopath affords no protection under section 84 as the law contained in this.
Just next sentence to start karantu. Behavior, antecedent, attendant and subsequent to the event. पढ़िले ना फिर?
हाँ again.
हाँ.
Behavior are antecedent, attendant and subsequent to the event may be relevant in finding the mental condition of the accused at the time of the event, but not that remote in time.
ये जोड़ा PW2 रो evidence आपण कहउछन.
Again.
Remote हे गले तार किसी मूल्य नाही.
Again.
सेही समयर जस्ट पूर्वरु कोन हेची से समय कोन हेची तापर those are all relevant consideration to give a finding on the mental condition.
PW2 my lord
PW10 परा कहला 10 वर्ष तळे ताकू ये
से कहिथिला पुलिस को कहिथिला ड्यूरिंग इन्वेस्टिगेशन से कहिथि जे मो पुलिस को इन्फॉर्म करथिली बट पुलिस हैज नॉट सेंट द अक्यूज्ड फॉर क्लिनिकल एग्जामिनेशन माय लॉर्ड
कोडी पुलिस को कहिछि से कहला
कहिछि
कोडी कहि आई मेड ए
10
स्टेटमेंट
years before मकर महंत एटा भूल लिखाइछि मकर महंत से 4 ओराम डेवलप्ड मेंटल डिरेंजमेंट आई मेड स्टेटमेंट टू पुलिस इन माय हाउस
मेड ए स्टेटमेंट माने जो तार रेकॉर्डिंग हला स्टेटमेंट ता घरे स्टेटमेंट देला पुलिस को रेकॉर्ड हला जो मेंटल डिरेंजमेंट भीतर कोठी कहिछि
पुलिस को कहिछि
कोन जहां नाही सब नै आसीबे ना कोन अपन लेखाइ जे आई मेड ए स्टेटमेंट टू पुलिस इन माय हाउस that means the statement he was recorded while the man was present in the house. That doesn't mean that he has stated about this mental ailment. How it be before 10 years before मकर
एटा भूल लिखाइ 4 ओराम ता
भूल किए करिवो witness sign maila you are present if your defense counsel doesn't bother to check it then bring it to the notice it could have been corrected otherwise माने session judge जदि किसी भूल recording हला how it is to be dealt with that is there once the witness ये कला seal मरा गला correctly explained and से तार signature कला तापर आपण केमती कहबे जे एडा मकर नुहे से एडा हबो माने ये बेली appellant बेली वे तो PW12 रो थाई पारे मेंटल प्रॉब्लम जो विषय रे से कहिथिबो
161 statement to police before the police investigation.
नहीं
किसी कहिछि कि
161 टा पेपर बुक रे नहीं
देखि देखि तथापि चेक करबो 16 बाहर करा ता ना होची
4 ओराम
नेमो
Dilnath Mahato.
पूर्ण ना को चारो PW2 न कोन दीनानाथ 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 महंत महंतर स्टेटमेंट बार
दिलनाथ मोहन
ठीक আজি রাতি 8:30 बेले मु एवं मोर जुआई मकर घरे भात खाउथिलु मोर स्त्री भात बाड़ी नहीं पाखरे छिड़ा होइथिला घर बारंडारे एक खट उपरे मोर नातुणी ममता शोइथिला पाखरे मो झियो सुभद्रा बसथिला हठात चारोरम दिया प्लान एक काठ ठेंगा धरी मोर घर भीतर को पशि आसला कहला मते बंचा बंचा मते किए मारिया को दौड़ी आसी मु देखिली जे केही लोक ता पछरे नथिले चार कहला आज जहाकू हेले तम घर लोक को हाणी जीवन ने मार देबी मोर राग शांत होइनी मु चारो कहली आ भात दीटा खाइले से मोर कथा न मानी आनीथिबा काठ ठेंगा को फिंगी देई आम घरे थिबा एक रंपा को धरी कहिला जहा कहले हाणिबी मु भୟରେ मोर भाई नंद को डाकी महंत घर को उद्धव महंत घर को थाना को फोन करिया पई गली फोन न लागिबार घर को फेरली देखली जे मोर नातुणी मरी पड़ी मोर झियो सुभद्रा स्त्री दशमी ज्वाई मते कहिले कि चारोरम एक टांगिया रे ममतार बेक हाथ को हाणी देइछि मोर ज्वाई मकर को टांगिया रे हाणीबा को गला बेले मोर ज्वाई मकर को टांगिया रे हाणीबा को गला बेले मोर ज्वाई तांको जीवन को बंचाई बाकू जाई चार ठारू टांगिया छड़ाई आनी तार गोड़ दुईटी को बाड़ी भांगी देले मोर स्त्री झियो ज्वाई सम्मुख रे चार ओर मोर नातुणी को आनी जीवन ने मारी देइछि झियो ज्वाई ओ स्त्री भय पाखु गले नाई मोर नातुणी आज को प्राय 4 वर्ष हेबो मोर घरे रहुथिला से द्वितीय श्रेणी रे बोधे पाठ पढ़े हाँ द्वितीय श्रेणी रे सुआनसो स्कूल रे पाठ पढ़ुथिला चारो ओर माजु को 3-4 वर्ष पूर्वे तार बड़ भाई को हानि थिला दिस इज द स्टेटमेंट नथिंग इज देयर दैट
बड़ भाई को हानि पड़ाई
हाँ so there is nothing from this decision says that if any material comes during course of investigation that this accused is suffering from any mental ailment, then it is the duty of the investigating officer to send him for medical examination and but nobody has stated except that particular line which you are pointing out from the PW2's evidence that also relates to PW12, not the appellant. So,
and after his arrest, when he was in jail custody, how he was behaving? Is there any medical report
No.
or to that effect that
This
he
is a
gave
jail
gap
criminal
of
appeal, my lord. He's a
like
poor man.
the case which we
other
had,
case, हाँ सीटर थिला मने ये थिला but
नहीं यदि तार इनसैनिटेशन थिबो बा तो फिर डेवलप करथिबो ना when he was in jail custody.
No evidence is
No
there.
evidence.
Lower court has, while tried the matter, so fastly tried the matter, but not given any importance on the prosecution to bring out the psychological development of the accused, my lord. He's only relied ବହୁତ ଫାଷ୍ଟ କରିଛନ୍ତି ଏଟା ଅକରାନ୍ସ ହେଇଛି 2004 ରେ ଡିସାଇଡ୍ ହେଇଛି 2005 ରେ
ଆପଣଙ୍କର
25/4
ରେ ଘଟଣା ହେଲା
ହଁ 25/4/2005 ରେ ତାର ଡିସାଇଡ୍ ହେଇଗଲାଣି
9 months.
but
He is in
the charge was framed on 5 to 2000 बोधे 5 हो 5/2/2005 रे 5 to 2005 आपणकर FIR ହେଲା 17/7 ଆଉ फाइनल फॉर्म सबमिट ହେଲା केबे फाइनल फॉर्म ହେଇଛି 6/10/2004 तो FIR 17/7/2004 CS 6/10/2004 केस कमिटमेंट के पहला so and so ऐसे again दियो ना अच्छा कमिटमेंट है कि नहीं आसिला सेशंस कोर्ट को 29/11/2004 हला देन चार्ज फ्रेम एटा होची सेशन जज रे रिपोर्ट पहुंचला then charge frame hela se charge kodala ka kon se paper book bahar kar charge frame hoichi 5/2/2005 now then witnesses were examined and witness mane डे टू डे ट्रायल करछंती 3 तारीख रे आपणकर 3 तारीख रे 1 2 3 4 5 हाँ किसी जेरा तो नहीं 9 अरे बा सब गोटे दिन ने कर दी जंती
PW 1 to 9 same
1
day.
to 9 अच्छा
ସେ ପୋଲିସର ଖାଲି ଟିକେ ଡେରି ହେଇଛି।
PW 1 to 9 on 3/2005 then 9 hela 1 to 9 gala tapare 10 hela 4/3 2005 then 10 11 12
13 and 14, your lordship.
13 and 14 right it's all right but you see question is that how you are prejudiced the London trial court has adopted the principle of speedy trial.
My lord,
Okay. If your
Significant.
claim is that no, I have not been provided proper opportunity, so you yourself didn't. I think the State Defense Council was examined. State Defense Council was engaged. Let us see that order sheet.
order sheet my lord ଦେଖନ୍ତୁ।
No opportunity. No opportunity was.
Never here place ये करना चाहिए जेरॉक्स करना चाहिए केबे दिया गला था चार्ज फ्रेम वाला केबे चला 5/2 रे
ଆଜ୍ଞା 5 ଫେବୃଆରୀ 2005।
S.K. Patra advocate is appointed as State Defense Counsel to defend his case. ସେଇ ଦିନ ଚାର୍ଜ ଫ୍ରେମ୍ ହେଇଗଲା Hmm. 5/2/2005 S.K. Patra SDC You see, on 5th, SDC was engaged.
My lord,
Then on 3/3/2005, you engage the private counsel. Accused is produced, Advocate R.P. Patnaik, C. Ram Mohan, S. Halua files B-Nama in favor of the accused to defend the case. In view of the engagement of the private defense by the accused, the appointment of SDC so and so gala ତେଣୁ କଣ ସେଟା ପଢି ହଉନି but so you engage your counsel. If your counsel will just put one question, only give suggestion, so who is to be blamed for that? You are now perhaps you are shifting the burden to the trial court that the counsel was incompetent and he did not put the questions to any of the witnesses, but we find that it is your counsel. So your private counsel conducted the case, and in spite of that, no cross-examination, and there was no material before the court. First, let us see that there was no material at the time of investigation. This decision says that if during investigation previous history of insanity is revealed, then it is the duty of the honest investigator to subject the accused to a medical examination, right? And place that evidence before the court. And if it is not done, then it creates a serious infirmity in the prosecution. Absolutely no material during investigation that the accused is suffering from insanity. So if that is the state of affairs and you entered into the house with a lathi, then stated something, then you assaulted that. So motive, even if stated that there was no motive on your part, but again, motive or no motive, that's a different fact. Motive assumes importance when there is absence of any direct evidence. In a case of circumstantial evidence, the motive is of pertinent significance. Okay. But otherwise, nobody knows what is there in the mind of a person, why he has killed. That only the person who has committed the crime, he might be knowing. So you cannot say that in a direct evidence case, the prosecution also requires to prove the motive part. That is not the law. So merely because prosecution fails to prove motive, according to you, why that man assaulted a 8-year girl child who was sleeping. But fact remains that number of eyewitnesses have stated that so absence of motive or non-proving the motive cannot be a ground to exonerate you from the offense.
But his behavior shows that he has some psychological problem.
So every problem will not bring your case to the mental insanity. That is you place that decision that mere abnormality of mind, partial delusion, irresistible impulse, or compulsive behavior of a psychopath affords no protection under Section 84 of the Indian Penal Code. Right? Behavior antecedent, attendant, subsequent to the event may be relevant in finding the mental condition of the accused at the time of, but not the remote point of time. So whatever PW2 stated, that is against some PW12 that he was suffering from, not about the accused. And number two, you came with a lathi was taken away. Then you said that I will kill one of the family members. Then you took that uh, axe from the house and assaulted that girl who was sleeping. And you might have also assaulted the others, but the man removed that, took away that axe from your hand and also caused injury on your person. Who knows that if that would have been there in your hand till the arrival of the police, you might have committed some other crime, might have assaulted some other person. Who knows that? And why he came, why he assaulted, why he wanted to kill one of the family members, that must be in the mind. It may not, but you see, in here also it is stated this very line: it is difficult to prove the precise state of offender's mind at the time of commission of offense, but some indication thereof is often furnished by the conduct of the offender while committing it and immediately after the commission of offense. A lucid interval of an insane person is not merely a cessation of violent symptoms of the disorder, but a restoration of the faculty of the mind sufficiently to enable the person soundly to judge the act. But the expression does not necessarily means complete or perfect restoration of the mental faculties to their original conditions. So, if there is such a restoration, the person concerned can do the act with such reason, memory, judgment as to make it a legal act, but merely a cessation of violent symptoms of the disorder is not sufficient. They say that the 105 burden of proof lies on you, and it is not that stringent to establish it beyond all reasonable doubt, and it can be established by preponderance of probability. But how you have established even by preponderance of probability? What about the other witnesses, Mr. Mishra? এই তো আই উইটনেস ছাড়ন্তু সে মেডিকাল এভিডেন্স গলা ଆଉ କିଏ କଣ କହିଛନ୍ତି?
Those are the only, Lordship.
Okay.
And these tests also, Your Lordship, are not applicable in this case because this very citation also states that as far as
No, there in that case there was medical report also.
medical report was there, and my lords, this is a case of inferential insanity, Your Lordship. So there is nothing on record to show that he was in fact that we can draw the assumption that he was in fact medically ill.
No, what he
Any
says that his contention that he would have escaped from the spot. Why he
Lordship.
remained, but rightly pointed out that he could not have because the two of the legs there was assault.
My lords.
So and that was fracture injury, not that. And you see the number of blows given and the part of the body. Very small child was sleeping, 8 years old. What sort of blows have been given? Neck, first blow, and second blow, left mandible, third blow on the right upper arm, fourth blow on the right forearm, and this impact is such it has caused fracture of right radius, and again the right upper arm no jo blow ta ଦେଇଛନ୍ତି ସେଇଟାକୁ right radius bone fracture, and axe was taken from your hand and that axe was also examined, and the doctor says that injury is possible by that axe. This is নাই কিছু case complaint. JCRLA number 108 of 2005. The appellant Charo Oram faced trial in the court of Ad hoc Additional Session Judge, First Track Court, Rourkela, in ST case number 270/2/040-05 for offense punishable under section 302 of the Indian Penal Code on the accusation that on 17th July 2004 at 8:30 p.m. at Hotang Udar under Bisra police station in the district of Sundargarh, he committed murder of Mamata कौन सेटा महर्तो ना कौन महा
মহাতো
माहातो
MOTH
MOHARTA लिखा है देखिए
না
लिखिए
আর নাই মহাতো খালি
अच्छा
MAHTO
अच्छा MAHATA कर दिया
ইউ
hereafter the deceased by intentionally causing injury to her person by means of tangia bracket लिख दें तो axe. The London Trial Court by impugned judgment and order dated 25/4/2005 found the appellant guilty under section 302 of the Indian Penal Code and sentenced him to undergo RI for life and to pay fine of rupees 5,000. In default of payment of fine, to undergo further RI for a period of 6 months more. Further period of more. The prosecution case, as per the first information report, lodged by Dilinath Mahato, bracket PW2, before the inspector in charge of Bisra police station on 17/7/2004, in short is that on that day at about 8:30 p.m., while he, along with his son-in-law, Mokar Mahato, bracket PW12, were taking their dinner, the appellant all on a sudden entered inside the house shouting "Banchao, Banchao," inverted comma with error there. Banchao, Banchao, he would be killed, inverted comma with error ends. The appellant was holding a weapon. ସେ ରମ୍ଫା ବୋଲି ଯୋଉଟା କହୁଛନ୍ତି ସେଟା କଣଟା?
ଯୋଉ ବାଲି ଟାଣନ୍ତି ଯୋଉ
ଆଁ
ବାଲି ରାମ୍ପିବା ପାଇଁ ସେ ଯୋଉ ୟୁଜ କରନ୍ତି ବିଲରେ ବାଲି ରମ୍ପା ହୁଏ ଯୋଉ
ଆଚ୍ଛା ରମ୍ଫା ବୋଲି କଣ ସେଟା ଦେଖିନି ଦେଖିଦେଇଥାଉ ତାକୁ ଦେଖିକିନି ତାର ଏଥିରୁ ଦେଖିକିନି ଲେଖିବ ହେଲା ଇଂଲିଶ ଡିକ୍ସନାରୀ. The informant told the informant PW2 challenged the appellant as to why he had come to his house. In reply, the appellant told that somebody was chasing to assault him, and he was angry and he would kill one person. Hearing such thing from the appellant, PW2, the informant, and PW12 told the appellant to immediately leave the house, and PW12 also took away that weapon from the hands of the appellant. The appellant all on a sudden picked off one tangia from the house of PW2 and told to kill one person. Out of fear, PW2 along with his brother Nando bracket PW9 proceeded to the house of one Udo to make a telephone call to the police station. But since he couldn't succeed in making the contact, he came back to his house and found that the deceased had already been killed by the appellant with a tangia. It is stated further in the first information report that PW5 Dasami Mahato, PW4 Subhadra Mahato, and PW12 Mokoro Mahato, who are the wife, daughter, and son-in-law of the informant, bracket PW2, had seen the occurrence. When PW12 registered to the appellant, the latter chased him to assault, but PW12 snatched away tangia from the hands of the appellant and gave 2 blows on the legs of the appellant, for which he received bleeding injuries and was lying in the house of the informant. Who is the investigating officer, Mr.
Samir Kumar Ponda, PW20.
Acha. PW2 informed the incident to the ward member Purno Mahato. Purno Mahato examine niche?
Yes, PW 16.
Bracket PW6.
16, my lord.
16. Acha. Who went to Visra police station, informed the police about the incident, and then police came to the spot where PW2 lodged the written report. Before PW20, Samir Kumar Honda, SI of police attached to Visra police station. And accordingly, the inspector in charge of Visra police station registered PS case number 61 of 2004 under section 302 of the Indian Penal Code against the appellant. As per the direction of the IIC, PW20 took up investigation of the case, examined the informant and the scribe of the report, Ramdeo Mahato, prepared the spot visit report, sent requisition for medical examination of the appellant to Rourkela Government Hospital, held inquest over the dead body of Mamata Mahato in presence of witnesses and prepared inquest report exhibit 4, seized the sample earth and bloodstain earth from the house of PW2 as per seizure list exhibit 5. The axe was seized from the place of incident as per seizure list exhibit 6. The dead body was sent for post-mortem examination and the wearing apparels of the deceased were produced by the constable who escorted the dead body for post-mortem examination, which were seized as per seizure list exhibit 10. When PW20 received in telephonic message from the medical officer, Rourkela Government Hospital, about the discharge of the appellant, he proceeded to the said hospital and arrested the appellant. The medical examination report of the appellant were collected. So also 3 numbers of X-ray plates and 1 full pant on production of the appellant as per seizure list exhibit 8. And then the appellant was forwarded to court. The seized axe was sent to the medical officer who conducted post-mortem examination for seeking his opinion regarding possibility of injury sustained by the deceased with such weapon, and the medical officer gave his opinion that the injuries sustained by the deceased were possible by the seized axe. Steps were taken by the investigating officer for sending the exhibits to FSL for examination and report, and on completion of investigation, charge sheet देखिए. Charge sheet कहीं final form दे दो. On 6/10/2004, charge sheet was submitted against the appellant under section 452 and 302 of the Indian Penal Code. Next para, after submission of charge sheet, the case was committed to the court of session after complying due procedure, where the London Trial Court framed charge against the appellant as aforesaid. Since the appellant refuted the charge, pleaded not guilty, the sessions trial procedure was resorted to establish his guilt. In order to prove its case, the prosecution examined such a number of witnesses, give the details. Prosecution also proved 11 documents, marked those exhibits and what are these. The defense plea is one of denial. The London trial court, after assessing the oral as well as documentary evidence on record, came to hold that the evidence of the eyewitnesses are quite independent, disinterested, and as such reliable. It was further held that the manner in which the appellant assaulted the deceased, who was an innocent 8-year-old girl sleeping, brutally on the vital part of her body like neck with deadly weapon like axe, coupled with the post-mortem report finding and the seizure of axe from the spot and the opinion given by the doctor who examined the axe and gave his opinion regarding possibility of the injuries on the deceased with such weapon. The London court came to the conclusion that the appellant committed the gruesome crime, having murdered a sleeping 8-year-old girl in the night of occurrence, and accordingly held the appellant guilty under Section 302 of the Indian Penal Code. Ms. Susmita Nando, London Counsel amicus curiae, argued that there was no motive on the part of the appellant to kill the deceased, a girl who was aged about 8 years old. And from the materials available on record, it indicates that the accused was having unsoundness of mind, at the time of occurrence. For which at the time of doing it, he was incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. And therefore, benefit of Section 84 of the Indian Penal Code is to be extended to the appellant, reliance has been placed on the decision of the Honorable Supreme Court in case of Prakash Nail NAYL versus State of Goa, reported in 2023 bracket ভিতরে bracket বারে 5 Supreme Court cases 673. The Learned Counsel further submits that the Learned Trial Court hurriedly disposed of the trial and although the occurrence took place on 17/7/2004, charge sheet was submitted on 6/10/2004 and the case came to the Court of Session after commitment on 29/11/2004 and the charge was framed on 5/2/2005. One day, that is on 3/3/2005, the Learned Trial Court examined PWs 1 to 9, out of which 4 of them were eyewitnesses to the occurrence. That is PW4, PW5, PW6, and PW8. Similarly, PWs 10 to 14 were examined on the next day, that is 4/3/2005, out of which PW12 is an eyewitness. The Learned Counsel argued that sufficient time has not been given to the appellant to prepare his case thoroughly and to consult his advocate, and by such speedy trial, the appellant has been seriously prejudiced. The Learned Counsel further submits that in view of the available material on record, taking into account the manner in which the trial has been conducted hurriedly, that too in a case under section 302 of the Indian Penal Code, and particularly in view of the available material on record to show that the appellant was having unsoundness of mind, benefit of doubt should be extended in favor of the appellant. Mr. S.K.MISHRA, Learned Additional Standing Counsel, on the other hand, supported the impugned judgment and submitted that even though at the time of framing of the charge, State Defense Counsel was engaged, but the appellant engaged his private counsel on 5/2/2005, which was almost a month prior to the commencement of the trial. And if the defense counsel engaged by the appellant would not put questions to the eyewitnesses, then the same cannot be a ground to hold that he has been seriously prejudiced. Had it been a case of State Defense Counsel conducting the trial, the matter would have been different. The Land Council further argued that the evidence of the eyewitnesses are consistent and most of them are related to the deceased, and therefore they are not likely to spare the real culprit and implicate somebody falsely. He argued that even though the prosecution has not established any motive behind the commission of the crime, but when the case is based on direct evidence of 5 witnesses, that is PW 4, 5, 6, 7, 6, 8, and 12, absence of proving the motive on the part of the appellant to commit the crime cannot be a ground to disbelieve the prosecution case. It is further argued that the manner in which a baby, the girl is at about 8 years while in a sleeping position has been brutally assaulted on the vital part of the body by an axe. The London Trial Court has rightly found the appellant guilty under Section 302 of the Indian Penal Code. He further argued that the case cited by the London Council for the appellant is quite distinguishable from the factual scenario of this case, and neither any medical evidence nor any clinching material evidence has brought on record by the appellant to discharge his burden in view of Section 105 of the Evidence Act, and therefore there is no infirmity or illegality in the impugned judgment, and the appeal should be dismissed. Adverting to the contention raised by the London Council for the respective parties, and before going to the evidence of the eyewitnesses, let us see the evidence on record how far the prosecution has established that the deceased met with a homicidal death. The inquest report marked as Exhibit 4 and the evidence of the doctor bracketed PW1 who conducted the postmortem examination on 17/7/2004 over the dead body of the deceased, very material in that respect. PW1 noticed the following injuries, external injuries. Quote all these things in page 24 of the paper book. He has opined that cause of death. The doctor has also examined the axe which was produced before him by the investigating officer with regard to the possibility of the injury sustained by the deceased, and he opined as per his report Exhibit 3 that the injuries sustained by the deceased would be possible by the axe produced. From the evidence of PW1, PM report Exhibit 2, so also the inquest report and other materials available on record, we are of the view that the prosecution has proved that the deceased met a homicidal death. The learned counsel for the appellant, the learned amicus curiae, has also not challenged this aspect. Therefore, we are of the view that the learned trial court has rightly come to the conclusion about the homicidal death of the deceased. Next, coming to the evidence of the 5 eyewitnesses to the occurrence, we find that PW4 so and so has stated that quote karibe seta ko hala dekhiye. In the cross examination, PW4 has stated that the appellant was telling himself that to give him marriage elsewhere, and he would obey everything when he came to the house. He further stated that when the appellant dealt blows to the deceased, they were on the veranda of the room, and though no electricity light was there in the house, but DBD light was burning in the veranda. Nothing has been elicited in the cross-examination to disbelieve the evidence adduced by PW4 relating to the assault made by the appellant to the deceased. PW5 has also stated about the assault of the appellant with an axe to the deceased while the deceased was sleeping on the neck and hand of the deceased while the deceased was sleeping, which led to his death, instantaneous death, except putting a suggestion in the cross-examination that he had not seen the occurrence. Nothing further has been elicited. PW6 has also stated, quote kar debe, and except putting a question that he was present in the house when the accused dealt blow to the deceased and giving a suggestion that he did not see the occurrence, nothing has been elicited. PW8 has stated like this, and a suggestion has been given that he had not seen the occurrence. PW12 has stated like this, quote it, and in the cross-examination, he has stated that there was no enmity of the appellant with the deceased, and the appellant had no relationship with the family of the deceased. And that he had also no enmity with the appellant. Therefore, the evidence of all the 5 witnesses have remained unchallenged. The eyewitnesses' version that axe was used to assault the deceased is getting corroboration from the medical evidence adduced by PW1. The axe was also seized and it was sent for chemical examination, and human blood was noticed on it. As per the C report marked as exhibit, markage na nahi?
Yes, Lord.
कितने number?
chemical examination nahi. Chemical examination nahi.
report on examination
ନାଇଁ ନା ସେଟା ୱେପନ୍ ଟା ସେଟା ମୁଁ କାହିଁକି ପଚାରିଲି ସେ ତା ଦେହରେ ମାର୍କ ଇଏ ନାହିଁ ନା ଯୋଉ all right ଲେଖିଦିଅନ୍ତୁ which though available on record but could not be has not been marked as an exhibit. Therefore, from the oral evidence of the eyewitnesses, oral account of the eyewitnesses, so also the medical evidence, it is clearly established that the appellant is the author of the crime, and on account of his assault, the deceased has sustained injuries as noticed in the post-mortem report. The Lenin Council submitted that since there was no motive on the part of the appellant and he did not try to escape from the spot, and PW2 has stated about the mental derangement of the appellant, the benefit of section 84 of Indian Penal Code is to be extended to the appellant. In case of so and so, it is held as follows. जोटा को अंडरलाइन ହେଇଛି ତାକୁ ଆପଣ କୋଟ କରିବେ ହେଲା ଆମେ ऑलरेडी अंडरलाइन ହେଇଯାଇଛି हां से रिलेवेंट गुड़ा. So far as the evidence of PW2 is concerned, in the cross examination he has stated that 10 years before Mokar Mohanta bracket PW12 developed mental derangement. He has not stated anything so far as the appellant's mental ailment is concerned. The Lenin Council submitted that it may be a typographical error, and in place of Mokar Mohanta, it should be read as Chakra Oram, the appellants.
Chara Oram.
Chara Oram, the appellant. We are unable to accept such submission. When private defense counsel are engaged in the case and they are cross-examining the cross-examining the witness and must have verified the deposition copies. If any typographical error was cropped up in the evidence of PW2, it should have been brought to the notice of the Lenin trial court so that it could have been corrected. After the satisfaction of the Lenin trial court. Since the same has not been done, we are not able to accept that what PW2 meant to say was that 10 years before the occurrence, the appellant developed mental derangement. Even the wife of the appellant being examined as PW 11 has stated in her cross-examination that she did not know what was the mental condition of the appellant while he was in house. However, he stated that 3 days before the appellant was sent to jail, he was not living with her and he was moving like a madman.
I do not know if he was.
And she further stated that she did not know if she was previously became mad. Since behavior antecedent, attendant, and subsequent to the event are the relevant factors for adjudging the mental condition of the appellant, and it should not be remote in time as per the settled position of law, and nothing has been brought on record by the defense. And when the eyewitnesses have deposed about the occurrence, absence of proving the motive is not a factor to disbelieve the prosecution case. Therefore, we are of the view that the contention of the London Council for the London amicus curiae that benefit under section 84 of the Indian Penal Code is to be extended in favor of the appellant is not acceptable to us. In view of the eyewitnesses' account, the postmortem report finding, the manner in which the occurrence has taken place, we are of the view that the London Trial Court has rightly found the appellant guilty under section 302 of the Indian Penal Code. Accordingly, the jail criminal appeal being devoid of merits stand dismissed, whether he was on bail or in custody.
He's in custody.
The report no vehicle. The superintendent said the applicant has been transferred to PG Patna Upandaya jail on the report might be.
All right. Put a note of appreciation on Ms. Nondo and Mr. Mishra, and 7,500 is to be given to me. Our judgment, however, will not debar the appellant, debar the authorities to consider the case of remission if he is entitled to
In terms of the guidelines,
no?
I want to make mention, my lord, out of the list, CRL 193 of 2023, the matter was heard on 2 occasions, my lord, and your lordship directed the State Council to take instructions regarding the antecedent of the
Bail matter.
Yes,
Give it.
Your lordship was pleased to direct to list this matter, but matter has not been listed.
What is the matter?
Well, matter, my lord.
On extension of time. Extension of time.
My lord, during pendency of appeal, the appellant died. I have filed a IA by the widow of the appellant filed a IA.
My lord, this is specific action for 20 for bail matter.
What is the matter? Bail matter.
Bail matter.
Lord, extension of time, my lord,
Hmm.
for surrender. Up to 10 years, my lord, 5 years in custody, my lord. Bail. 10 year conviction of 5 years.
Criminal revision, my lordship. Criminal revision. In last occasion, 211 was specified for the adjournment, but not been listed yet. In last occasion, it said to 211 of 2013 to be listed, but it not been
What is
listed.
that revision for?
CRL. CRL.
You are mentioning
Discharge petition.
a
Discharge petition.
Give it. Yeah.
No, the CRL is 186 by 2023 my lord, appeal bail, my lord. I have prepared,
Give it.
the item number 13 may I prefer withdraw, my lord.
I think it is CRLA number 56 of 2024.
My lord, on the
All right.
like
Memo file disposed of pursuant to here.
Supplementary list, item number 21.
My lord, with respect to pendency of criminal cases, I would like to place cross-examination of PW1 from paragraph 49 to 66. 70. Paragraph 70.
Paragraph?
Paragraph 49 to paragraph 70. That will clear all doubt. 70. 70. Evidence on affidavit, A, cross-examination, page 11, PW1. Paragraph 49.
Yeah.
My lord, I have filed Exhibit 17 to show that Purighat PS case number 149 dated 11/9/2018, which corresponds to GR case number 1722 of 2018, pending in the Court of Law and SDJM Sadar Kotak against the respondent Muhammad Mukim and others. In Exhibit 1 to 4, so also in Exhibit 32 to 35, in the affidavit of the respondent Muhammad Mukim filed in Form 26, the aforesaid case details of Purighat PS case number 149 dated 11/9/2018 with the correct GR case number and offences as well as the name of the court have been mentioned in column 5II-A 1, 5II-B 1 and 5II-C 2. 50. I have filed Exhibit 18 to show that Purighat PS case number 150 dated 11/9/2018, which corresponds to GR case number 17.
This is in the cross-examination.
Cross-examination.
Yeah.
2723 of 2018, pending in the Court of the Law and SDJM Sadar Kotak against the respondent Muhammad Mukim and others. Exhibit 1 to 4, so also in Exhibit 32 to 35, In the affidavit of respondent Mohammed Mokim filed in Form 26, the aforesaid case details of Purighat PS case number 150 dated.
Mr. Mishra, I have checked it up everywhere. She yesterday where he is differing from that. Rest of the thing.
No, everywhere. Gotti kiri
ମୁଁ ଦେଖି ସାରିଲିଣି already ସେଟା
ଆଜ୍ଞା
ଯେ କୋଉଠି କଣ
17 କୁ ମାନିଛନ୍ତି
18 କୁ
ମାନିଛନ୍ତି
18 କୁ correct ଅଛି ବୋଲି ମାନିଛନ୍ତି
19 କି ମାନିଛନ୍ତି
20 କୁ ମଧ୍ୟ ମାନିଛନ୍ତି ଏକ୍ଜିବିଟ୍ 20 କୁ ମଧ୍ୟ ଠିକ ଅଛି ବୋଲି କହିଛନ୍ତି
କେବଳ 26 ଟା
ହଁ ଯୋଉଟା ମୁଁ ସେଇଗୁଡାକ ଆସୁନି କାରଣ ବାକି
26 ଟା ସେ କହୁଛନ୍ତି
22 23 24
ଆଜ୍ଞା
ସବୁ ଠିକ ଅଛି ଦେନ୍ 25 ଠିକ ଅଛି
ଆଜ୍ଞା
ଓକେ 26 ରେ ହଁ 26 ରେ
26
କଣ
ଟା does not relate to me ବୋଲି କି କହୁଛି
just place that then response they called in
paragraph
58
15
I have filed exhibit 26 which relates to Kotak Vigilance PS case number 34 dated 31/8/2007 under section 13(2) read with section 13(1)(c)(d) of PC Act and section 419(120)(b) of the Indian Penal Code which corresponds to TR number 16 of 2010 pending in the Court of Learned Special Judge Vigilance Kotak against Hitindra Nath Man and Vijay Kumar Marandi and others, and also the charge sheet submitted in the said case to show that such a case is not pending against respondent Muhammad Mokim, even though in the affidavit filed by the respondent in Form 26 in column 5II XII, it is mentioned that FIR number 34 dated 6/9 a date dita को compare कले जଣା पड़िबो कि अलगा date of vigilance police station Kotak Odisha is pending against him and its TR case number and offences have not been mentioned in 5IIB and 5IIC respectively.
Vigilance police station कटक भुवनेश्वर जगह कटक कर दी
no ऊपर तो लिखा ହେଇଛି कटक विजिलेंस केस
ଆଜ୍ଞା
ସିଏ କଣ ଦେଇଥିଲେ କଟକ ଲେଖିଥିଲେ
भुवनेश्वर जगह कटक
okay
that is the mistake
that means two mistakes are there one is in place of Bhubaneswar it is mentioned as Kotak tapare date of registration of the FIR is
different
that
is correct 6/9/2007
no 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 ଆପଣଙ୍କର ଏଇଟା ହଉଛି ଯୋଉଟା ଫାଇଲ କରିଛନ୍ତି
ସେ ଫାଇଲ କରିଛନ୍ତି
ହଁ 34 ଶୁଣନ୍ତୁ FIR କଟକର 34 ନମ୍ବର କେସ୍ ଦିଥର ରେଜିଷ୍ଟର୍ଡ ହୁଏନି ତେଣୁ FIR ନମ୍ବର 34 ମାନେ ଗୋଟେ ଡେଟ୍ ରେ ରେଜିଷ୍ଟର୍ଡ ହେଇଥିବ ରାଇଟ୍ ସିଏ ଦେଖଉଛନ୍ତି ସେଟା ଫାଇଲ କରି 26 ରେ ଯେ 34 ନମ୍ବର କେସ୍ ଟା ରେଜିଷ୍ଟର୍ଡ ହେଇଛି 31/8/2007 ରେ ଯୋଉଥିରେ ଆପଣ ମୁଦାଲା ନାହାନ୍ତି ଆପଣ ଯୋଉ କେସ୍ ଟା ଦେଖେଇଛନ୍ତି ସେଇଟା ହଉଛି ଆଉ ଗୋଟେ କେସ୍
6/9/2007
it is mentioned
number 34 6/9/2007
is pending against him and its TR case number so and so has not been mentioned then
that is the difference
okay
date number FIR number date ठीक अछि केवल विजिलेंस पुलिस स्टेशन भुवनेश्वर जगह कटक
okay तापर next 59
टा exhibit 27
तादरे कोन भूल है
relates to Valyanta PS case number 136 dated 24/9/2012 registered under section 417 341 323 294 506 379 120B and 34 of the Indian Penal Code which corresponds to GR case number 680 of 2012 pending in the court of the JMFC O Bhubaneswar against respondent Muhammad Mokim and others in which the order sheet indicates that on completion of investigation charge sheet has been submitted on 12/11/2015 under section 341 294 506 120B and 34 of the Indian Penal Code and accordingly as per order dated 7/12/2015 cognizance of such offences has been taken and it further reflects that the respondent Muhammad Mokim is on police bail granted by this court in BLPL 222
ଓ ଏଇଟାରେ ଅଛି ଆପଣଙ୍କର SDGM ଭୁବନେଶ୍ୱର
ଆଜ୍ଞା
ଯଦିଓ ଅର୍ଡର ସିଟ୍ ଟା ଦେଖୁଛି ଏଟା JMFC ଓ
ଓ
ଭୁବନେଶ୍ୱର
ଭୁବନେଶ୍ୱର
ଆଉ ବାକି ସବୁ ଠିକ ଅଛି
ବାକି ସବୁ ଠିକ
ଏବଂ ଦଫା ଅଧିକା ଲେଖିଛନ୍ତି ବୋଲି ସେଠି ବି କହିଛନ୍ତି ତାପରେ
ହଁ
କିଛି ଦଫା ଅଧିକା ଲେଖି ଦେଇଛନ୍ତି ଏଥିରେ।
କୋଉଟା
ଏଇ କେସ୍ ରେ
ନାଇଁ ଅଧିକା ଦଫାରେ କେସ୍ ଟା ରେଜିଷ୍ଟର୍ଡ ହେଇଥିଲା ଯେତେବେଳେ ଚାର୍ଜସିଟ୍ ହେଲା ସେତେବେଳେ ଦଫା କମି ଯାଇଛି
କଟିଗଲା
ହଁ
ଲାଷ୍ଟ ନେକ୍ସଟ ପେଜରେ ମାଇନରିଟି ପାଇ
ହଁ
ସିମିଲାରଲି ଯୋଉଠି ଅଛି
Similarly, in column number 5 IIC XII of the said affidavit, some of the offences like Section 3 of PDPP Act, Section 7 of Criminal Law Amendment Act, and Section 96 of Odisha Urban Police Act, and Section 147, 353, 427, and 149 of Indian Penal Code have been incorrectly reflected, though the case was never filed for such offences.
केस टा भी फाइल ହେଇନି କି ଚାର୍ଜସିଟ୍ ବି ହେଇନି ତା ଦେହରେ
ନାଇଁ
ହଁ
ଚାର୍ଜସିଟ୍ ହେଇଛି ମାଇଲର
ନାଇଁ ଚାର୍ଜସିଟ୍ ଏଇ ଅଫେନ୍ସ ରେ କୋଉଠି ହେଇଛି ଚାର୍ଜସିଟ୍ પર ଆପଣ ଦେଖିଲେ ଉପରକୁ ଜଷ୍ଟ 3D PBP ଆକ୍ଟ ରେ କୋଉଠି ଚାର୍ଜସିଟ୍ ହେଇଛି
ସେଥିରେ ହେଇନି ଆଜ୍ଞା।
ସେଥିରେ ହେଇନି
ଓ ସେଇଟା ତ ସେଇଆ
ଏବଂ ସେଠି ଦେଖିକି ଟିକେ
ଏଇ ପର୍ଟିକୁଲାର କେସ୍ ରେ
20/9/2022 ରେ ତାଙ୍କର
ହୁଁ
ଆଫ୍ଟର ଫାଇଲିଂ ଅଫ ଦି ନୋମିନେସନ
नो व्हाट दे से दैट ଆପଣଙ୍କୁ ସେ କେସ୍ ରେ ବୋଧେ ତା ଆଗରୁ ବେଲ୍ ରେ ଯାଇଛନ୍ତି ବୋଧେ
ହଁ ବେଲ୍ ରେ
ହଁ ତେଣୁ ସେଇଆ ସେ କହୁଛନ୍ତି ଯେ ୟୁ ଆର ଏଇଟା ମୁଁ ଯୋଉ କାଲି କହୁନଥିଲି ଯେ ଟୋଟାଲ ଜାଣିନଥିବ ଅଲଗା କଥା
ଆଜ୍ଞା
ଆପଣ ଏଠି ଆପିୟର କରିଛନ୍ତି ବେଲ୍ ରେ ବି ଯାଇଛନ୍ତି
ଆଜ୍ଞା
ତେଣୁ ସେଇଥିପାଇଁ ସେ କହୁଛନ୍ତି ତା ସତ୍ତ୍ୱେ ମଧ୍ୟ ଏଇ ଯୋଉ ଭୁଲଟା ହେଇଛି SDGM ଜାଗାରେ JMFC ଓ ଜାଗାରେ SDGM ଲେଖିଛନ୍ତି ଯଦିଓ ପ୍ରଥମରୁ ସେ କେସ୍ JMFC ଓ କୋର୍ଟରେ ପେଣ୍ଡିଂ ଅଛି ଇଏ ଗୋଟେ ଜିନିଷ ଆଉ ଗୋଟେ ହଉଛି ଏଇ ଯୋଉ ଅଫେନ୍ସ ଗୁଡାକ ଲେଖି ଦେଇଛନ୍ତି 3 PDPP ଆକ୍ଟ ଦେନ୍ କ୍ରିମିନାଲ ଲ ଆମେଣ୍ଡମେଣ୍ଟ ଆକ୍ଟ ଆଉ ଅର୍ବାନ ପୋଲିସ ଆକ୍ଟ ଏଇଗୁଡାକ କଣ ସେ ତା ଦେହରେ
ନାଇଁ
ନାହିଁ ଅଲରାଇଟ୍ ନେକ୍ସଟ
then exhibit 28 paragraph 60 to show that Bhubaneswar Vigilance PS case number 15 dated 16/3/2011 which corresponds to VGR number 15 of 2011 is pending in the Court of Law and Special Judge Vigilance Bhubaneswar against respondent Muhammad Mokim and others for commission of offences under section 13(2) read with section 13(1)(d) of PC Act 1988 and section 420(1)(20)(b) of Indian Penal Code, which has been mentioned in column 5IA X, 5II-B X, and 5II-C X of the affidavit filed by respondent Muhammad Mokim in form 26 dated 3/4/2019 in connection with his nomination paper dated 2/4/2019 under exhibit 1, 2, 3, 4, 32, 33, 34, 35, the order sheet of the said VGR case exhibit 28 dated 22/9/22 indicates that final report number 8 dated 38/22 has been received by SP Vigilance Bhubaneswar Division, Bhubaneswar, and notice has been issued to the complainant for filing protest petition, if any, fixing the date to 12/12/22. I have not filed the final report.
এইটারে କଣ ଭୁଲ ହେଇଛି ଏଇ ଯୋଉ
କିଛି
ଆଚ୍ଛା
କିଛି ଭୁଲ
ତାପରଟା ଯୋଉଠି ଭୁଲ ହେଇଛି ମତେ ଦେଖାନ୍ତୁ ଆଉ ଅନ୍ୟ ଗୁଡା ଦେଖାନ୍ତୁନି
ଭୁଲ ସେ ଦେଖେଇ ସାରିଲେଣି
ଗୋଟେ ଯେମିତି ସେ ଯୋଉ JMFC ଓ ଆଉ କିଛି ଯଦି ଠିକ ତ ଅଛି ଆଉ କଣ
ତାପରେ ମାଇଲର ଏକ୍ସିବିଟ୍ 29 ରେ ବି ସେ କହିଛନ୍ତି କରେକ୍ଟଲି ରିଫ୍ଲେକ୍ଟେଡ ପେଜ 20 ରେ ଲାଷ୍ଟ କୁ ଅଛି
ପେଜ ର ପେଜ ସେଇ ଯୋଉ 29 ର କୋଉଠି ଅଛି କରେକ୍ଟଲି ରିଫ୍ଲେକ୍ଟେଡ
ପାରା 61 ତାର 20 ପେଜ 20 ରେ ପାଇବେ ଲାଷ୍ଟ କୁ ଠିକ ଦେଖେଇଛନ୍ତି
The said aspect has been
ମେନସନ କରେକ୍ଟ ଛାଡନ୍ତୁ ସେଟା ଛାଡନ୍ତୁ ନେକ୍ସଟ
ତାପରେ exhibit 30 ସେଥିରେ ବି ସେୟା କରିଛନ୍ତି aspect has been mentioned ସେଇ 20 ର bottom 3 line
ହଁ କରେକ୍ଟଲି ମେନସନ ଠିକ ଅଛି 63 କଣ କହିଲେ
63 I have no knowledge that apart from the 13 cases in which I have filed certified copy of FIR, charge sheet and order sheet, any other case is pending against the respondent Muhammad Mokim. I have filed the certified copies of those FIRs and other documents as has been mentioned by the respondent Muhammad Mokim in his affidavit in form 26 to be pending against him. ଆପଣ ବି ତାଙ୍କୁ ପଚାରିଛନ୍ତି ସେଇଥିରେ For the second time, I contested the election of MLA against the respondent Muhammad Mukim, though I had knowledge that some criminal cases have been instituted against the respondent Muhammad Mukim prior to the election in year 2019, but I had no knowledge about the details of those cases, including the offences involved and the courts where those cases were pending. In order to verify whether respondent Muhammad Mukim has reflected correctly about the pendency of the cases against him in the affidavit, I applied for certified copies of the FIR, charge sheet and order sheet, and then I came to know about the correct state of affairs. So jaha kahile aguru sab kahi gale. ଆଉ ସାର୍ଟିଫାଏଡ କପିଟାକୁ ବି ଆଣିଲେ ସେ କୋର୍ଟରେ ଆପ୍ଲିକେସନ ଦେଇକିରି ସାର୍ଟିଫାଏଡ କପି ପାଇଛନ୍ତି। From the date of application of certified copy and grant of certified copy, it reveals that I got those documents after filing of the election petition. If you ତାପରେ ଆପଣ ପ୍ରଶ୍ନ କଲେ, if you have got the certified copies of the FIR, charge sheet and order sheet after filing of election petition, how you mentioned in the election petition that respondent Muhammad Mukim has not correctly reflected about the case details in the affidavit in Form 26. After verifying from different agencies and making research prior to obtaining the certified copies, I came to know that respondent Muhammad Mukim has given wrong statement in affidavit in Form 26. Paragraph 54. Page 24 bottom ku sir dekhun.
24.
Agya.
Paragraph 65 ରେ ଅଛି କିନ୍ତୁ ସାର୍ ଯୋଉଟା ପ୍ଲେସ୍ କରିବେ 24 ର
Bottom.
ଲାଷ୍ଟ ସପାର
24 ଟା କାହିଁ ରେ? ତା bottom ରେ ଅଛି
I have filed exhibits. I have filed exhibit 17 to 30 relating to 14 criminal cases, out of which exhibit 26 is the certified copy of FIR and entire order sheet of TR number 16 of 2010 pending in the Court of London, Special Judge Vigilance Kotak, which was neither instituted against the respondent Muhammad Mukim nor he has been charge sheeted in the said case, even though he has reflected in his affidavit in Form 26 to be pending against him. Exhibit is 17 to 25 and 27 to 30. The respondent Muhammad Mukim is an accused. 13টা case ଆମେ 13ଟା ଯାକ reveal କରିଛୁ. Exhibit 18 to 21 indicates 18 and 21 indicate that for obtaining the certified copy of such documents, applications were filed on 25/6/19 and the certified copies were granted on 28/6/19. I have filed the election petition on 3/7/2019. Exhibit 18 and 21 were available with me when I filed the election case. In paragraph 7C of the election petition, I have mentioned that the respondent in his affidavit dated 3/4/2019 filed along with his nomination paper on 2/4/2019 has falsely and deliberately not made correct, proper and full declaration about details of criminal cases pending against him. It is a fact that in paragraph 7C of the election petition, nothing has been stated in connection with exhibit 18 and 21 relating to any suppression, misleading statement by the respondent in his affidavit in Form 66. It is a fact that at the time of filing of election petition, exhibit 17, 19, 20, 22, 23, 24, 25, 26, 27, 28, 29 and 30 were not available with me, which I received in between August 22 to November 22. It is a fact that in paragraph 7C of the election petition, I have highlighted the suppression misleading statements made by respondent in his affidavit in Form 26 with reference to 3 cases only. that is exhibit 26 ଯୋଉଥିରେ ଆମେ involved ନୁହଁ 27 and 30 so sum total ହଉଛି 27 and 30 ଉପରେ ସେ କେବଳ କହିଛନ୍ତି then 68 in the affidavit as well as in the verification in the election petition I have mentioned in paragraph 4 that the particulars of such illegalities and irregularities as alleged in 7A to 7J are based on my personal knowledge and on the basis of documents filed by the respondent before the returning officer and official records and public documents, which I believe the same to be true. ଏଠି କହିଲେ ଯେ ମୁଁ various agency ଆଉ research କରିକିରି ଜାଣି Therefore, he has given a false statement on oath before this honorable court. I do not remember whether the respondent has submitted the copies of Exhibit 17 to 30 along with his affidavit in Form 26. The documents Exhibit 1 to 4 and 32 to 35 were shown to the witness and following questions were asked. Whether copies of Exhibit 17 to 30 are available in Exhibit 1 to 4 and Exhibit 32 to 35. Even after brief verification of the aforesaid exhibits, I cannot say whether copies of Exhibit 17 to 30 are available in Exhibit 1 to 4 and Exhibit 32 to 35 or not. It is not a fact that I have got no authentic information in support of my statement, which I have made in election petition in paragraph 7C or in my evidence affidavit relating to suppression of criminal cases pending against the respondent in his affidavit in Form 26, and that I am making fishing and roving inquiry about this same. This is all about criminal cases. Your Lordship, another thing I beg to urge before your Lordship about issue 3 ଟାକୁ ଟିକେ ଦେଖ
ଇସ୍ୟୁଟା କର
issue 3 that relates to ସେ ଯୋଉ ଆମକୁ ଯୋଉ କପି ଦେଲେ ଇଲେକ୍ସନ ପିଟିସନର ସେଥିରେ ଯୋଉ ଚାଲାଣ ସେଥିରେ ରିସିଭଡ୍ ପେମେଣ୍ଟ ଷ୍ଟାମ୍ପ ବାଜି ନଥିଲା ପେମେଣ୍ଟ ହେଇଛି କି ନାହିଁ ସେଇଟା ଆପଣ କୋର୍ଟରେ ଡାଇରେକ୍ସନ ଦେଇକିରି ଆସର୍ଟନ କଲେ ଯେ ନାଇଁ ପେମେଣ୍ଟ ହେଇଛି we are not on that we are on the simple question ଯେ true copy ଆମକୁ ଦବା ଯଦି ସେଇଟା ନ ଦେବେ ତାହେଲେ it is liable to be dismissed.
I have noted down when you are arguing that
ଆଜ୍ଞା
here
ସେଥିରେ ତାଙ୍କର ଯୁକ୍ତି ଥିଲା ଚାଲାଣ is not a part of
the
election petition. ଆପଣ ତାଙ୍କୁ କହିଥିଲେ ଗୋଟେ ଡିସିସନ ଅଛି ଯଦି ଦିଅ they have not filed it so far. Our content reply on the alternative is Challan is a part of the election petition will be evident from the conjoint reading of different sections. Yes, Section 117, 81.3, 86.1, 117. First 117 टाइप सारे देखो
କୋଉ section
117 ଟା ଫାଷ୍ଟ ଦେଖନ୍ତୁ ତାପରେ ମୁଁ 81.3 କି 83.1 ଆଉ 81(3) ଆଉ 86(1) କୁ ନେଇ
117.
ଆଜ୍ଞା
Hmm.
ତାର ଓପନିଂ ସେଣ୍ଟେନ୍ସ ହଉଛି at the time of presenting an election petition. That is the catch one.
Hmm.
The petitioner shall deposit in the High Court in accordance with the rules of the High Court a sum of rupees 2,000 rupees as security for the cost of the petition.
Hmm.
Two-ଟା ଆଉ କିଛି ଦରକାର ନାହିଁ. Then your lordship may kindly come to first come to section 80, chapter 2. No election shall be called in question except by an election petition presented in accordance with the provisions of this part. By an election petition. Then 81(3) hela an election petition calling in question any election may be presented on one or more of the grounds specified in subsection 1 of section 100, section 101 to the High Court by any candidate at such election or any elector within 45 days from, but not earlier than the date of election of the returned candidate, or if there be more than one returned candidate at the election and the dates of their election are different, the latter of those two dates. Then 3 is important. Every election petition shall be accompanied by as many copies thereof as there are respondents mentioned in the petition, and every such copy shall be attested by the petitioner under his own signature to be a true copy of the petition. ଏଠି ବି ସେ ଚାଲାଣକୁ attest କରିଛନ୍ତି true copy ହିସାବରେ. ମୋର submission before your lordship is catchword is section 80 रे election can be called in question, no election can be called in question except by an election petition. Here is petition. Then 81 रे election petition calling in question. Emphasis is on petition. Here also 3 रे every election petition, and 17 रे at the time of presenting an election petition. So challan is a integral part of the election petition, and without the challan the election petition is incomplete. That is my respectful submission before your lordship, and not maintainable. धन्य जो election petition challan टा नथांता कि received payment stamp टा नथांता तार सेही ग्राउंड रे भी election petition टा dismiss हो जाइथा. 86 रे the High Court shall dismiss an election petition which does not comply with the provisions of section 81, 82 or section 107. ଆପଣଙ୍କର ରିପୋର୍ଟ ଅନୁସାରେ ପେମେଣ୍ଟ ହେଇଛି, ରିସିପ୍ଟ ପେମେଣ୍ଟ ଷ୍ଟାମ୍ପ ବାଜିଛି, କିନ୍ତୁ ଏ ଯୋଉ 81 ଆଉ 83 ଇଏ ଆଉ କମ୍ପ୍ଲାଏ 81(3) ଟା ଆଉ କମ୍ପ୍ଲାଏ ହେଲାନି. ଟ୍ରୁ କପି ଆଉ ଆସେଟ୍ସ ଲାୟବିଲିଟିଜ ଉପରେ କିଛି କେସ୍ ନାହିଁ କି ପ୍ରମାଣ ନାହିଁ. With this I conclude my reply.
So now please both of you tell to when we'll fix that
Note.
date for
Note.
note citation jaha bhi apan daba
We will
kata
give by Monday, my lord.
ha
We will give by Monday.
nahi apan exchange kar debe na apan
I'll serve copy also.
Fifth. They are saying
Fifth,
on
huh.
fifth. We will also give on fifth.
ଆପଣ କାରଣ ସେଗୁଡା ସବୁ disorderly manage ରେ ସେଟା
କହିଲେ କଣ ଯୋଉଟା ରହିବନି କାହିଁ କହିବି
ଆଉ ଟିକେ ଯୋଉ ଇଏରେ କହିଥିଲି ଯୋଉ ଇସ୍ୟୁଜ ଗୁଡାକର ଜଏଣ୍ଟ କରିକିନି ତାକୁ
ସେଗୁଡାକ ଦବୁ
ହଁ
ସେଇଥିପାଇଁ ଟିକେ ଟାଇମ ଲାଗିବ ତ
ନାଇଁ ମାନେ ଆପଣଙ୍କର ତାଙ୍କର ଯେମିତି ମାନେ ସିଏ ଧର ମନେକର ଇସ୍ୟୁ ନମ୍ବର 1 2 3 4 ଗୋଟେକରେ ଦେଲେ ସେଇ ହେଡିଂ ରେ ଆପଣ ବି
ଆସିବ ସିଏ ତାକୁ କେମିତି deal କରିବେ
We have submitted, my lord, what are the groups of the issues.
ହଁ
At
କାରଣ
the
ଆପଣ
time of
ଯେତେବେଳେ
argument.
ଆର୍ଗୁମେଣ୍ଟ କରୁଥିଲେ
ସେଇ group
ଜଏଣ୍ଟଲି
ଆମେ ଯୋଉ ଅନୁସାରେ ଗ୍ରୁପ କରିକି
ହଁ ହଁ ମୁଁ
ଦେଇଥିଲୁ ସେଇ ଅନୁସାରେ
ସେଇ group ଅନୁସାରେ
କାରଣ ଓବିୟସଲି ପ୍ରାୟ ଏକା ରହିବ କାରଣ ଗୋଟେ ଗୋଟେ ଏଇ ଇସ୍ୟୁ ଗୁଡାକ ଏଇ
ତାପରେ ବି
ପର୍ଟିକୁଲାର ଆସ୍ପେକ୍ଟ
ଆପଣଙ୍କ କନଭିନିଏନ୍ସ ପାଇଁ ଯୋଉ ମ୍ୟାଟେରିଆଲ ପୋର୍ସନ ଅଫ ଏଭିଡେନ୍ସ ଏକ୍ଜିବିଟ ସେଗୁଡାକ ବି କୋଟ କରିବା କଥା ସେଇଟାକୁ ଟିକେ ଡେରି ହବ ବୋଲିକି ମୁଁ ଭାବୁଛି
ନାଇଁ ଆପଣ କୋଟ ନ କରିକିନି ବେଟର ଏଇ ଯୋଉ
ଖାଲି
ଏଇ
ପାରାଗ୍ରାଫ
ଏଇ ଲାଇନ ଟୁ ଏଇ ଲାଇନ ଏମିତି ଲେଖି ଦଉନାହାନ୍ତି ମନେକର
ହବନି
କଣ ହବନି
ସେଟା ଇମ୍ପ୍ରେସିଭ ହବନି ଆପଣଙ୍କ ଆଖିକି ଆସି ପଡିବନି ସେ ଜିନିଷଟା ରହିଲେ ମ୍ୟାଟରଟା ରହିଲେ ଆପଣଙ୍କ ଆଇ କ୍ୟାଚ୍ କରିବ ସେଇଥିପାଇଁ ମୁଁ ଭାବୁଥିଲି ଟିକେ ଆମର ଟାଇମ ଲାଗିବ ସେମାନେ ଯଦି ଆଗରୁ ପ୍ରିପେୟାର କରିଦେବେ
No, I cannot give you. The day you will supply, I will supply you on the very same day.
ଆପଣ ମାନେ ମତେ ଆଉ ଇଏରେ ପକାନ୍ତୁନି ମତେ
I can file, my lord, by Monday.
I want at least 2-3 weeks to prepare it. ହଁ now
ଦେଇ ହବନି ଆପଣ ଶୁଣୁନାହାନ୍ତି କି why you are insisting ଆରେ ସିଏ ଯେତେବେଳେ ଦେବେ ତମେ ଦେବାକୁ ବାଧ୍ୟ
because Mr. Mishra, I do not know who has cited that decision. It says that for the written note of submission.
At the time, when my lords were hearing right to begin that
right. So still then I am giving you time.
ମୋର ଗୋଟେ personal difficulty ହଉଛି I have shifted from Bhubaneswar to Cuttack. My office is not in order. That is why I am.
So you are now getting 5 days time. So you have already started preparation. Must have started. So
କରିଛୁ ନ କରିଛୁ ବୋଲି କଥା ନ କରିଛୁ
entire milord in the last week the notification will be made by February 20th. Entire exercise will be futile.
Move. See, 27 actual election. 27th election likely जो जिनसटा आपण apprehend करछनी सेटा जदी हेई गला
entire exercise will be futile.
election अछि मु सेगुडा को better let us not discuss about that. You file it your और जहा करिया कथा 5th रे रख दउछि आपण माने फाइल कर दो लिखि दम से argument is
ମୁଁ 7th ରେ ଦେବି
all right then I will keep it on 7th.
7
so hard Mr. Vidyadhar जहा थिला लिखि देबे सेही एटा argument is closed and both the land and council submit that they will file their respective written note of argument and citations if any on 7th of February 2024 hala list this matter on 7th February 2024 at 2 p.m. for submission of written note of submission written note of argument and citations if any hala only for say purpose remain ठीक है
আমরা রেফারেন্সটা দিয়ে দেবা দিয়া আসছে
Supplemental list item number 1.
Yes, sir.
May I please, sir? My lord, pay one password, my lord. My senior is just coming, my lord.
What is the offense here? Just a minute.
Offense, my lord, the appellant has been called.
306 re. Page 49.
That is the highest punishment.
My lord, for this accused, my lord.
Huh?
For this accused. This appellant.
Two accused persons.
This man is M. Rajesh Patra.
My lord, Rajesh Patra.
And
For Bhagya Lakshmi Patra, there is 8 years.
okay. So this the accused was on bail during
My lord.
Hard admit, call for the trial court report. The appellant was on bail, no chance of early hearing, bail allowed, stay relation of fine. Yes.
Obliged.
Item 2.
Mr. Onita. Conviction, please. What is the sentence imposed?
2 years.
He was on bail during trial.
They have stated this. And I'm hiding my appearance.
Okay. এটা লেখা ହେଇଛି second page ରେ ଲେଖା ହେଇଛି bail ରେ ଥିଲେ। Mr. Sriman Das, senior standing counsel, files the appearance memo. Is taken on record. Hard admit. Call for the trial court record. He was on bail, bail allowed, stay relation of fine. Free copy of the order be handed over. Yes. And henceforth the name of Mr. Das be reflected in. Okay. Yeah.
Item 3.
May I please? The appellant is convicted under Section 13(2) of PC Act.
Sentence.
2 years and 10,000 rupees fine.
You were on bail during trial.
My lordship.
Yes, Mr. Das. So
I'll file my appearance by the end of April.
So Mr. Sanjay Kumar Das, learned standing counsel for the Vigilance Department, submits that he has received the copies of the appeal memo along with the interim application and will file the appearance memo such and such. Admit, bail granted, he was on bail, stay relation of fine. Free copy of the order be handed over. Name of Mr. Das be reflected in the top of the brief as well as the cause list henceforth. Yes.
Obliged.
Free copy of that.
Yes.
Item 4.
Please, Your Lordship, the operative portion is at page 47. Second paragraph. May I read, my lords? I sentence the convict to undergo rigorous imprisonment for 10 years and pay a fine of 1 lakh in default to undergo further rigorous imprisonment for 1 year for the offence under Section 21C of the NDPS Act.
Okay. Admit, call for the trial court report. Interim application for bail and stay relation of fine to be considered after receipt of the trial court. Deposition copy to be supplied to the land council for the state. Yes.
Yes, I am supplying the copy of the deposition to my land.
Supplied with full. Yes.
Item 5.
May I please, Your Lordship? My lord, the appellant has been convicted under Section 498
रखिए डिले कंडोन कर देवे हला जेल क्रिमिनल अपील एडमिट कर देवे बाकी मिस्टर दास जा ना देवे यस नेक्स्ट
Item 7.
यस कौन डिफेक्ट अछि ओडा
This matter was yesterday, my lord, so far as an quack is concerned, my lord. The defector state copy.
स्टेट का भी दे दी
Yes, yes.
बाकी रहला अंडरटेकिंग आउट रहला ओके तेरा कौन है सीआरएल
This is ST, my lord. Bail.
अच्छा so somebody has entered appearance
Yes, yes, my lord. J. Panda, my lord, appeared.
so you have received the copy of the case diary
Case diary is available 8, item 8.
हाँ सही एका
Yes.
केस तो होगा the 7 and 8 गोटे
Yes,
केस
yes.
रो तो argue the matter
So this is the third journey, my lord. Earlier it was
this
filed and
Jitu Maji earlier approached this court for bail
both, my lord.
both okay
Yes.
so last time when the bail application was rejected and where is that order
That order is not uploaded, my lord, but it was.
Yes, yes. And first case, page 19, understood 2.
I vanished. That was filed by me, 957.
সেটা হচ্ছে 24/1/2023
The direction was given to move after the.
in view of the eyewitness account of informant kono Jaya Mani Maji
Yes, my lord.
the widow of the deceased Kesari Maji and the manner in which the crime has been so and so I am not inclined okay so kon hala ya pore kon position
Examined, victim examined, turned hostile, my lord. I have given the deposition copy, my lord.
এটা eyewitness support কলানি তা
না, না,
wife support কলানি
ନାଇଁ ଆଜ୍ଞା।
There are other witness also.
ନାଇଁ ଆଉ କିଏ ଅଛନ୍ତି କହୁନାହାନ୍ତି
Yes,
material
that
witness
is Raut Maji is there.
so you do one thing Mr. Mishra Mr. you give the names of those eyewitnesses
Yes.
you kouchandi so that I will the necessary arrangement will be made that summons will be
Issue to
received
them, yes.
and he will so give that name
Yes,
okay
ma'am.
the
Yes,
learned
but-
counsel for the petitioner appellant submitted that when the petitioner approached this court last time for bail in CRL number 957 of 2022 the
Thereafter also approached me.
last time ta kadi it was rejected in view of the availability of the eyewitness account of informant Jayamani Maji, the wife of the deceased Kesari Maji, and London trial court and appellant was given liberty to renew his prayer for bail after examination of the informant and other material witnesses. The London counsel for the petitioner submitted that though that informant has been examined in the meantime as PW1
Yes, sir.
and he or she has not supported the prosecution case. However, the London counsel for the state submitted that there are other material witnesses like ethical chardiyandu say Mr. Lekhin in view of such submission made by the land council for the state let the inspector in charge of Thuamul police station Thuamul tana Thuamul Rampur nago
Yes,
Tuamul Rampur.
Thuamul Rampur police station shall appear before the London trial court that is so and so on or before good date debe receive summons in respect of the aforesaid witnesses ensure their attendance on the date fixed put up this matter ତା ଗୋଟେ ସପ୍ତାହ ପରେ ରଖିବେ କେବେ ତାରିଖ ଅଛି କୁହନ୍ତୁ ବୁଝିକିନି କହିଦିଅନ୍ତୁ ହେଲା the London counsel for the appellant shall produce the certified copy of the deposition of the witnesses aforesaid witnesses if examined ହେଲା same order କରିଦିଅନ୍ତୁ item number 8 ରେ ହେଲା
A free copy.
free copy of the order
already yesterday another matter was there that was fixed to week commission 5th. That must
fifth মানে
next week, my lord.
ଫିଫ୍ଥ ରେ କୋଉଠି ସବୁ ଆପଣ ପୁରା ସାକ୍ଷୀ ଗୁଡାକ ହେବେ
ନା
ସିଏ
କାଲି ଯୋଉଟା ଥିଲା ସେଥିରେ କରିଛନ୍ତି, ତେଣୁ ଏଇଟା ବି ସେତିକି ଯାଉ।
କାଲି ଯୋଉଟା
କାଲି ଗୋଟେ ଥିଲା
ହଁ
1293 that
ଆଚ୍ଛା
matter has been fixed.
ଲିଷ୍ଟ ଦିସ୍ ମ୍ୟାଟର କରିଦିଅନ୍ତୁ along with କରିଦିଅନ୍ତୁ what is the number
1293.
1293 of 2023 CRL number all right yes
My name is
Written note I am supposed to file by which date?
अच्छा हार्ड मिस्टर पंडा आपण ना लिखिबि ना कोन
ନାଇଁ ନାଇଁ ଆଜ୍ଞା ଆମ ରିଟର୍ନ ନୋଟ ଟା ଆମେ କେବେ ସୁଧା ଦେବୁ?
7th ରେ ରହିला
I'm sorry ମାଲୋ ଚାଉ
नो नो इट्स ऑल राइट से मु तां कहउतली 5 तारिख दिए ना से कहले ना आउ 2 दिन दियंतु 7th रे उभय पक्ष देबे yes and there should be an exchange of notes on
yes
yeah. So it will with CRL actually. So Mr. Tripathi it is your duty to
Yes,
that yes
third
ma'am.
date में फीस
ଆପଣଙ୍କର ଆगे ବୁଝିକିନି କୁହନ୍ତୁ ଡେଟ୍ ଟା କେବେ ଅଛି ଡେଟ୍ ଟା ଯୋଉ ଦିନ ଥିବ ତାର ଗୋଟେ ସପ୍ତାହ ପରକୁ ରହିବ ତେଣୁ ଆପଣ ହିଁ ଜାଣିପାରିବେ ଡେଟ୍ ଟା କେବେ ହେଲା ଇଏ
Item 9.
yes Mr.
Once you can see the date chart. 22/7/2023, the alleged occurrence took place at about 3 p.m.
Yeah.
And thereafter again at 8:30 p.m. 23/7/2023, FIR has been registered under Section 300. And the petitioner arrested from custody from 23/7/2023. And charge sheet has been filed on 18/11/2023. 302/34 along with 3 of the SC/ST Act. Your my lord,
What is the name of the deceased?
Bhaskara Tandi.
there is absolutely, I will submit before beginning placing the materials. That so far 302 is concerned, there absolutely there is no material against the petition.
Is there any eyewitness, Mr. Mishra?
Look, the eyewitness, here the prosecution case is that the deceased was a drunkard and habitual, is a history seeker involved in many cases. He used to collect chanda from the village every day for drinking and for other purposes. This is a prosecution case. And on the day of occurrence, he came and asked for chanda to the accused person. Then he refused. Then he broke the auto of the petitioner. Then again in the evening, the auto was broken and he was found injured and dead. This is the situation, the prosecution case. And they have stated in my petition also.
About the assault part on the deceased.
My lord.
Who has stated about
the
that?
Prosecution case is that your lordship kindly see the FIR. Sorry, the FIR is probably
ଧମକ ଦେଇଥିଲା ତେଣୁ ମୋର ଭାଇ ରାଗ ହୋଇ ତାର ଅଟୋ ରିକ୍ସା ର କାଚକୁ ଭାଙ୍ଗି ଦେଇଥିଲା ଠିକ ଅଛି ପୁଣି ମୋର ଭାଇ ଭାସ୍କର ତାଣ୍ଡି ରାତି 8:30 ବେଳେ ନିକଟରେ ପ୍ରେମରାଜ ପୋଡଙ୍କ ଘର ବାଟ ଦେଇ ଆସୁଥିଲା ବେଳେ ମୋର ଭାଇ ଭାସ୍କର ତାଣ୍ଡିକୁ ପ୍ରେମରାଜ ପୋଡ ଗୋଟେ ମେଢାରେ ମୁଣ୍ଡରେ ନିସ୍ତୁକ ପ୍ରହାର ଦେଲା ଫଳରେ ମୋର ଭାଇ ରକ୍ତାକ୍ତ ହୋଇ ଅଚେତ ହୋଇ ପଡିଲା. So this man is not an eyewitness. This is an informant.
But eyewitnesses are there.
Who has stated that?
More than 5 to 6%.
So just name one person.
One I am saying, my lord, the Jugala Naik.
Jugala Naik.
34.
What he has stated?
I have given the entire evidence in the statement of all.
Jugala Naik's statement are ଦେଇଛନ୍ତି.
Suppose.
Jugalal Naik, my lord, sir.
Juglal.
Juglal Naik. Juglal
Naik.
Juglal LAL.
Shall I please?
ପଢିଲେ ଗୋଟେ statement ପଢିଛନ୍ତି.
ମୋର ନାମ ଯୁଗନାଲ ନାୟକ, ବୟସ 60। ଆଜି ତା 23/7/2023 ତାରିଖରେ ଉପରୋକ୍ତ କେସ ତଦନ୍ତ ଦେବା ମୁଖ୍ୟ ପାଇଁ ଏଇକି ଯେ ଭାସ୍କର ତାଣ୍ଡି ଓ ପ୍ରେମରାଜ ପୋଡ ମଗେଶ୍ୱର ପୋଡ ସମସ୍ତେ ଆମ ଗାଁର, ମୁଁ 3 ଜଣଙ୍କୁ ଜାଣିଛି। ଗତକାଲି 22/7/2023
अपराह्न समय आम पड़ार क्लब पाखरे भास्कर तांडी पवित्र तांडी एवं आमर ग्रामर प्रेमराजपुर बयस सो मध्य पूर्व शत्रुता को नहीं बचसा होई पाटितुंड होइतला। एथिरे प्रेमराजपुर भास्कर तांडी को जीवन में मारिदेव बोली धमक चमक देइथिला। तेणु भास्कर तांडी रागरे प्रेमराजपुर डाहाण गोड़ को पिटी देइथिला। प्रेमराजपुर गोटे 3 चकिया ऑटो रिक्शा जार नंबर सो काच को भांगी भास्कर तांडी संपूर्ण भांगी देइथिला।
तमने डिसीज्ड
broke the glass of the auto rickshaw of the
हाँ नहीं
accused
डाहाण
number
गोड़
one.
को भी पिटी थिला कहउचंदी
Right.
assaulted on the right leg गोटे तापरे तार ऑटो भांगी देइथिला।
नाइला।
अच्छा देन कौन हला राती
देन राती 8:30 बेले भास्कर तांडी प्रेमराजपुर घर पाट दे आसुथुवा बेले भास्कर तांडी को प्रेमराज ऑटो भांगीवा राग रखी जीवन रे मारदबा उद्देश्य नहीं गोटे मेरारे तार मुंड मुह को निस्तुक माड़ मारला। तापर तार बापा मगसीर पोड़ गोटे बाउंस ठेंगा आनी भास्कर तांडी को जोर बाड़ेला। उभय मिसी भास्कर तांडी को पिटिले फल भास्कर तांडी रक्तारक्त हुई अचेत हुई आम घर बारंडा पाख गाँ रास्ते पड़िला ऊपर पड़गला। या परे ताको चिकित्सा पे रास्ता मरे।
And here the interesting point with the Lord,
yes
to whom the informant has named to have known from the incident, their statement is not recorded by the police for the reasons best known to them, which I have stated in paragraph 4 of my ground. Matter of fact, the witnesses claimed by the informant to have witnessed the occurrence were not examined. The other court of witnesses are examined.
what is the PM report?
PM
Yes.
report matter craniocerebral injury and
No,
and
what is that report?
7 injuries are there, my lord.
Not grievous. This report is that not grievous or not on vital part.
Head
ଦେଇଛନ୍ତି କି ଆପଣ?
I have stated in paragraph 5 that your lordship can see if it is wrong. The PM examination reveals that the injuries were also not grievous and not on vital part of the body.
Antemortem in nature produced by hand
They
death
were
is due
going
to
to anti-
craniocerebral injuries returned times in
and that weapon also
And the
seized, my
background
lord.
of the case is
My lord, I'm for the informant.
Sorry.
I'll hear you. Why are you in a hurry? When a senior counsel is arguing, have patience. Am I not here? I'll not hear you or what? Yes.
The manner in which the entire occurrence took place as per the prosecution. Admit it will be a case of 304 maximum if at all there is material. But in view of that vital omission by the prosecution to suppress the truth, why he did not examine the witnesses who are named by the informant to have seen the occurrence? There is no reason for that. And your lordship can see the PM report. And Kato Merare Mari, he is a history seeker. That has not been taken into consideration by the investigating officer or the court bill. Large number of cases are pending as him. It was his habit to collect chanda and drink and do some other nefarious activities in the village every day. And the prosecution said that he came once refused, he broke upon, and again he came in the evening. And suppose, even assuming but not considering that somebody became annoyed and assaulted, that can't be said to be a case of 302.
What is your submission, Mr. Tripathi?
My lord, fracture injuries are there, so that
Yes.
cannot be.
What about the
And
antecedent of the
antecedent of the accused, my lord? So far, antecedent of the accused, there is no antecedent.
neither? There are two
Two
appellants.
accused, but they do not have any.
Yes. What is your sub? Now you
But
sub.
my lord, leading to
Leading
discovery
discovery
was
is there, man.
and both the weapon being seized, and the query report is also there that weapon would have been used for that purpose of the
Okay.
injury.
Yes.
That
What
is
is your submission?
My lord,
One
leading
small
leading
reply to
discovery.
what my Alfred said is all regarding so-called a prima facie case. Your lordship knows that the Constitution bench judgment, the
Yes.
bail is the rule. My Alfred has not whispered a single thing, excepting the little bit of prima facie case, why he should be detained. He has not said anything. That we are with on the basis of material on record. What to speak of material on record, no submission has also been made that we are likely to tamper with the evidence. All other paraphernalia which has been given to refuse that to come under the exception, because that is the law is that to.
Yes. Yes. Yes.
May I submit, my lord? one thing, my lord, that is leading discovery is there. The weapon, the leading discovery is there, my lord. The weapons that is, my lord, on bamboo and on wooden meher have been seized by the police, my lord. So far as the indicating the case diary, my lord. And there is more than 5 eyewitnesses there who have seen the occurrence, my lord. And the case is of 302, my lord.
No, what Mr. Mishra is arguing
My lord.
about the genesis of the case, why this occurrence took place. The occurrence took place because you are the person, the deceased is the person who first assaulted the accused, right?
In that case, he might
Number two, not only that, the auto rickshaw that was broken. Auto rickshaw was the source of living of a person that you broke. So that was the background of the case. And when obviously he has committed the offense, so this no report seems to have been lodged for that assault and the auto rickshaw. But this deceased was coming on that, and when he was passing, then he was appears that he was confronted about why you have done all these things. Okay, then maybe some kind of scuffle, some kind of, then this incident took place. You are right that
if any
the
wrong
number of injuries have been caused. Okay, number of injuries have been caused, and the report is that also that the death was caused on account of craniocerebral of injuries. So apart from that leading to discovery, there are eyewitnesses account.
5, 6 eyewitnesses.
So,
Query report is also there.
Query report.
If any wrong happened, my lord, he can take shelter of the law, my lord. If any wrong happened to him, he can took shelter of the court of law, my lord.
All right, no,
My
those are
In
the
spite of
things,
doing that, he take revenge, my lord.
those are the things which definitely are to be adjudicated at the stage of trial by
He
the
take
when the
revenge. This
evidence
is not
there.
acceptable in law.
Whether it will be acceptable or not, it is the statements of the witnesses. It's not that he is making out a defense plea here. What he is submitting on the basis of the statement of those eyewitnesses whom you are relying upon. Your eyewitnesses have stated that it is the deceased who first assaulted the appellant. It is the deceased who first broke the auto rickshaw of the appellant. So that was the background. That took place in the afternoon. This incident took place in the evening hours at about 8 o'clock.
What about my submission, my lord? He can approach the police, my lord.
Mhm.
If his wrong happened to him, he can take shelter of the police, my lord.
That's not, there is no, he is not taking a right of private defense nor in a bail application. I am here to adjudicate where he is submitting that entire scenario in which the thing has happened. And Mr. He is submitting that this deceased is also having some cases against him.
That
There is no such
there.
thing. All right. Heard Mr. S.K.MISHRA and counsel appearing for the appellants, learning counsel for the state and learning counsel for the respondent number 2. Mr. Mishra submitted that the petitioners are in judicial custody in connection with this case since 23/7/2023, and they have been charge sheeted under section 302/34 of the Indian Penal Code and section 32B of the SC/ST POA Act. He further submits that the eyewitnesses account indicate that it is the deceased who was the aggressor, and he assaulted the appellant number 1, Premraj Sport, and then broke the front glass of the auto rickshaw of the appellant number 1. And due to such overt act committed by the deceased, the occurrence has taken place, and it is stated that both the appellants assaulted the deceased by means of lathi and merha. The Land Council submits that the petitioner, the appellants have got no criminal antecedents, and even if it is stated that prima facie case is made out on the basis of the statements of the eyewitnesses, but in absence of any material that there is any chance of absconding or tampering with the evidence, the bail application may be favorably considered. The London Council for the state placed the evidence, the statement of eyewitnesses, particularly the statement of Juglal, Juglal
Naik.
Juglal Naik, and further praised the post-mortem report, which indicates that the cause of death was on account of craniocerebral injuries. The Land Council submits that the weapon of offense seized was sent to the doctor who conducted post-mortem examination, and he opined that the injuries sustained by the deceased were possible by such weapon. However, he submits on verification of the case record that the appellants have no criminal antecedents. The London Council for the informant opposed the prayer and submitted that whether the case would come within the scope of right of private defense or not is to be adjudicated at the time of trial, but the manner in which the appellants have taken the law into their own hand on account of the overt act committed by the appellant, on account of the overt act committed by the deceased, and the post-mortem report finding, bail should not be granted in favor of, bail should not be granted to the appellants. Considering the submission made by the London Council for the respective parties, nature of accusation against the appellants, the surrounding circumstances under which the offences alleged to have been committed, absence of any criminal antecedent against any of the appellants, and further taking into account the period of detention of the appellants in judicial custody, I am inclined to release the appellants on bail subject to condition that they shall appear before the London trial court on each date when the case would be posted for trial. They shall not try to tamper with the evidence. Violation of any terms and conditions shall entail cancellation of bail. Yes.
And producing the CA report.
A CA report produced and taken on that. Yes. Yeah, basically.
Item 10.
I don't know. The
Item 12.
Please, madam.
Notice to be go.
This is appeal matter.
Fresh matter.
Yes, my lord.
Fresh matter. Extra copy to be served.
I mean, court I'm submitted.
Delhi.
Yes.
Acha. Served before in court. Notice CDCA. Gote saptah pore. Yes, next.
Item 14.
But 12th of March,
Gote saptah tale 12 तारीख ଆସିବ. Yeah. Mr. Dibedi. Fresh matter.
3 STS and 376 2
Fresh matter tho. So
one copy serving matter.
अच्छा extra copy served in court कर दियंतु. Then बाकी सब CDCA some. Yes, next.
Item 15.
Withdrawal memo accepted, disposed of as withdrawn.
16.
Yes, what is this matter?
I'm praying the matter may be taken up before rising. Mr. Ponda is just on his way, my lord.
कौन टा matter टा कौन है? Criminal appeal टा कौन है?
It is challenging the order passed by the learned sessions judge Bhubaneswar rejecting the petition filed by the petitioner under section 340 of the CRPC that an inquiry may be conducted about the false evidence given by some of the witnesses who has been named as eyewitness during the trial.
Page 97 is the impugned order. All the witnesses have been examined. Now it is pending for arguments, this case. They have filed a document, they filed an application stating that these eyewitnesses have given a false version before the court. That's why the case should be instituted against them. And that has been rejected by the court, Your Lordship.
All right. Next week, yes, next.
Item 17.
May it please, my lord. On behalf of Mr. Mahapatra, I may be permitted.
Which one?
Item 17, my lord.
17, Mr. Raghunath Ponda Lekhaiji, advocate. This is CRLA number 1126.
26, my lord.
Okay. What is the CRLA for?
It is against conviction, my lord.
So there is some delay or what?
Yes, my lord. There's a delay of 34 days, my lord. IA has been filed. IA number 310.
What is the conviction?
My lord, the operative part is at page 42.
42.
I sentence and convict, namely Jagatram Kishan alias Pradhan, to undergo RI for 10 years and with fine of rupees 10,000 in default to undergo RI for 3 months for offence 3042 of the IPC.
All right. Yes, I'm condoning the delay. IA number so and so. This is an application for condonation of delay. Stamp reporter has pointed out delay of 34 days in filing the criminal appeal. Considering the submission made by the Land Council for the respective parties, going through the averments taken in the interim application, and since it's a case of conviction where 10 years of substantive sentence has been imposed on the appellant, I am inclined to condone the delay. Accordingly, delay is condoned. IA is disposed of. Hard admit call for the trial court record. There is no other application.
There's an IA 2460.
Acha, the interim application for bail and stay realization of fine to be considered after receipt of the trial court record. Deposition copy to be supplied to the Land Council for the state. Yes.
Obligement.
Item 18.
May please, Your Lordship.
What is the delay? 40 days.
40 days, man.
42 days. And sentence is
10 years, my lord.
offense
Offense 395.
95. Yes, Mr. Mishra.
Lordship.
So delay is 42 days. So delay condone. IA disposed of, admit, and this bail and stay is to be considered after receipt of this. No? Yes.
Item 20.
May please. 413 days. Deposition copy, sir.
Sir. Deposition copy supplied in court.